Test 1 2 3, 1 2 3.
Good morning, everyone. Judge Rovner, good morning to you.
Good morning, everyone. Good morning to you and to Judge Lee.
Good morning.
We have 6 cases on today's argument calendar. The court will take a brief 10-minute recess after the second argument. We'll begin with appeal number 23-3268, Michael Williams versus Dylan Radke. Mr. Ondrak.
Good morning, judges of the Seventh Circuit. Good morning, counsel. My name is Rex Andrig, and I represent the petitioner appellant, in this case, Michael Williams. We appreciate the opportunity to be here this morning. At its core, this case is about the reasonable doubt standard that Winship held is a due process protection in criminal cases. More specifically, it's about how that standard is animated in the form of a jury instruction so it can be properly applied to a particular case by a criminal jury. The United States Supreme Court recognized in both Cage and Sullivan that if a jury instruction does not properly convey Winship's concept of reasonable doubt and unfairly dilutes it, a due process violation that requires conviction It's a due process violation that requires the conviction be reversed. The question ultimately under Victor is whether there's a reasonable likelihood that the jury instruction is understood to allow conviction based on proof insufficient to meet the Winship standard.
Mr. Andrig, forgive me, the jury instructions were quite lengthy and did include multiple directives that seem favorable to Mr. Williams. How then do you believe, in the context of all these favorable directives, could the one sentence permit the jury to convict Mr. Williams with certainty that, is less than beyond a reasonable doubt?
It is true that the instructions, Judge Rovner, in various places correctly state the burden of proof, and that reasonable doubt, for example, is embedded in the substantive instruction. And the jurors were told that it was their duty to give Mr. Williams the benefit of every reasonable doubt. But the problem here, in my opinion, is not with the definitional aspects of this instruction. The problem is sort of with the operating instructions that the jury was given. Because after telling the jury that the state is required to prove guilt beyond a reasonable doubt, the jury then essentially was told not to examine the evidence for reasonable doubt. But that's exactly what a criminal jury must do, to breathe life into the reasonable doubt standard. If you're instructing the jury not to do that, I think you're effectively canceling out the applicable burden of proof, or really diluting it. All it really takes is one juror to hear that instruction and that command and decide that, well, she should not scrutinize the evidence for doubt. And then you've got, I think, the right to a trial by a jury is violated. And I think it's bad enough you tell the jury not to scrutinize the evidence for doubt. I think it's much worse when simultaneously you instruct the jury that what they really should be doing is looking for the truth. This
Mr.
jury,
Ondrak, if you focus on the standard that Congress has supplied in Section 2254D, do you agree that the jury instruction that is being challenged here is not contrary to any U.S. Supreme Court precedent?
I do agree.
Okay. And so therefore the question becomes, with respect to the Trammell decision, right, which is, by extension, the reasoning that the Wisconsin Court of Appeals adopted here, what U.S. Supreme Court precedent do you believe Trammell reflects an unreasonable application of?
I believe it reflects an unreasonable application of Winship. I believe it also reflects an unreasonable application of Victor.
Okay. And Winship is pertinent to the inquiry, but Victor is much more on point in the universe of a beyond a reasonable doubt instruction. What aspect of Victor do you believe Trammell can't be squared with?
I think that it can't be, and I think Victor kind of is repeating this from the Holland case. I don't think it can be squared with the idea that you take a look at the instruction as a whole. I don't think Wisconsin has ever really given serious attention to the problems with the jury instruction in this case. Of course, the Court of Appeals just relied on Trammell, and that was appropriate in this particular case. Trammell, however, focused mostly on these two research studies that apparently suggested that this type of instruction is more likely to lead to false convictions.
But if you go back to what you just said, the point you just made, you made in response to Judge Rovner's question too, and that is you seem to acknowledge that you should read the instruction as a whole and not just focus on one particular sentence.
Correct.
Okay. If you do that, I have Victor in my hands right now. What aspect of the Trammell reasoning reflects an unreasonable application of the principles the U.S. Supreme Court relied upon in Victor?
Well, first of all, I mean, I think Trammell did recognize that you have, the unreasonable application, I think, is sort of the fact that if you read the instruction, I think reading the instruction as a whole, you've got, as I stated before, you've got a reasonable doubt standard that's sort of set forth correctly. But I don't think that Trammell really understood that if you read and it's really the Avila case.
That may be, but I mean, maybe I'm mistaken, but I think you have to cast your arguments in terms of error vis-a-vis U.S. Supreme Court precedent. And the reason I'm saying that is because of the language of 2254 D1.
Right. I think the way that I see it is that we've got a situation here where it's really not, one thing I want to point out to the court that I think is really important is that one thing that neither Trammell nor Avila, and I think Avila is really the last Wisconsin Supreme Court decision to actually address this issue, because Trammell really didn't address the issues that we're raising here. But I think the problem is, for example, there's language in this jury instruction that was not addressed by Trammell. And that's specifically the language where the judge said just before the jury retired, "Let your verdict speak the truth." And that language was not examined by Trammell, was not examined by Avila. They were just looking at the language that said, your job is to search for the truth. And I think that it's much more forceful. I mean, I think there's a meaningful difference between searching for the truth and then telling the jury. I mean, that's sort of like the job that they're supposed to do.
I hear you. I'll just ask the question one more time. You have to prevail, in my view, you have to demonstrate that the Wisconsin Court of Appeals decision reflected an unreasonable application of U.S. Supreme Court precedent.
And I think
it's the only way, for better or worse.
I think the unreasonable application is that when it examined the question of whether the instruction as a whole was reasonably likely to allow the jury to convict on less than the Winship standard, it really didn't examine. I mean, it basically just said, here's the instruction as a whole, and we think that it's okay because it's got all of this other stuff, all of the proper reasonable doubt definitions and so forth. But it didn't really examine what telling the jury not to search for doubt does. It just kind of looked at the thing as a whole and then simply sort of stated in conclusory fashion that because all of this other stuff is here, we think this instruction is okay, without ever actually examining what this language of don't search for doubt, search for the truth, what kind of an impact that's going to have on a jury.
Mr. Andrick, do you think that the placement of the last sentence makes it even more problematic? In other words, there's this long instruction, and at the very end of the instruction, it says, "You are to search for the truth." Do you think that the placement that, the jury leaves with truth ringing in its ears?
I do think that's problematic. It's sort of the recency bias. I think in this particular case, it's even worse that after we had the improper remarks by the prosecutor, the court came back and reiterated that language, and that's when we got the "let your verdict speak the truth." And the problem I have is that the jury may have been properly told about the reasonable doubt standard and may have been given a proper definition of reasonable doubt. But if its marching orders are to go and let your verdict speak the truth, I don't know how a defendant can get an acquittal unless the jury makes a determination that his innocence is the truth. So again, I think the definitional aspects of the instruction are okay. It's just the operational aspects of this instruction that concern me.
So if in that operative sentence that we're focusing on, if the trial court had omitted "you are not to search for doubt" and simply state, "while it is your duty to give defendant the benefit of every reasonable doubt, you are to search for the truth," do you still find that problematic?
I do find that problematic, that the search for the truth language. I think what the easy fix here...
And I guess my question, echoing what Judge Scudder said, is, Victor talks about kind of moral truth and whatnot. And I'm wondering why you think instructing a jury to say that you are to give every reasonable doubt and you are to search for the truth, how is that inconsistent with the court's holding in Victor?
Because I think, and I don't know if it's Victor so much as it may be more Winship, that there are cases, and this court has said that ultimately a trial is about a search for the truth. But I think that when that was said in those cases, it was with regard to testimony, and there was some discussion about cross-examination, and I think the rules of evidence and so forth is all sort of designed to get at the truth when testimony is being offered. But truth is not the touchstone. I mean, nothing in the Constitution makes searching for or finding the truth a criminal jury's deliberative task. We have, I think that we, sort of hope that ultimately this system leads to the truth more often than not. But I don't think that jury trials are really meant to be, in a criminal context, a search for the truth.
Before you have to go, and time flees, I really wanted to ask you about the prosecutor's comments. I understand from the court reporter's transcript that Mr. Williams objected to the prosecutor's calling his defense moldy, old, ratty. But when the sidebar was over and the prosecutor continued, why didn't Williams' attorney not object to the 5 pieces of evidence for which the state claimed he had no answer? And because there was no objection at that point, why hasn't he forfeited his objection to the prosecutor's statements that he had no answer to those 5 pieces of evidence? And I also was wondering, of the 5 pieces of evidence, which the prosecutor claimed he had no answer for, which claim from the prosecutor most directly commented on his choice not to testify? Or did all of them, in your view?
I think all of them did in my view, and I sort of viewed, I understand what you're saying, Judge, that there was no specific objection made after the fact about those 5 particular comments, but I sort of viewed that this whole idea of a ratty old, moldy old defense that doesn't have any good evidence, and that's why you get that kind of a ratty old, moldy defense. I think that the 5 comments by the prosecutor were just sort of an extension of that. I wish the record had been more specific that he was objecting to those 5 remarks, but I read the record as being an objection to the whole thing, and he moved for a mistrial. So I see I'm out of time. I don't know if you want me to continue, Judge. I'm not sure I answered the entirety of your questions, but.
That's fine.
Great.
And thank you.
Thank you.
Okay, Mr. Andre, thank you. We'll give you 1 minute of rebuttal time.
Okay, thank you.
You come back. Okay. Mr. Conway, good morning.
And good morning, and may it please the court. I'm Michael Conway on behalf of the respondent, Dylan Radke. This court should affirm the magistrate judge's order denying Mr. Williams' petition for federal habeas relief. And as this court was getting at, the magistrate judge correctly denied the reasonable doubt instruction claim because the state court did not unreasonably apply Victor in determining that the reasonable doubt instruction as a whole accurately conveyed the state's burden of proof.
I take it that the Wisconsin pattern instruction, JI 140, is given as a matter of course in Wisconsin trial courts. Is that correct?
That is correct.
Yeah. I really found that quote in footnote 3 of the appellant's brief from the University of Pittsburgh Law Review striking, that Wisconsin is the home of probably the most constitutionally defective burden of proof instruction in the country. How would you respond?
I would respond that that was the opinion of one academic, and here under section 2254, we're looking at whether Victor was unreasonably applied. And a thing I think is really important to note about Victor is that Victor disapproved the use of moral certainty. They looked at the instruction as a whole and considered it and said, please don't use this anymore. It puts your instructions at risk. But even if it is imprudent, it is not unconstitutional. And here we need, Mr. Williams has not even established fair-minded disagreement among the lower courts about the use of truth language. There is certainly cases where it's grudging acceptance of the use of the truth, but not even the lower courts have been saying truth vitiates an otherwise valid reasonable doubt instruction. And what Mr.
Williams posits that the instruction pitted the concepts of doubt and truth against each other. And it appears that at least 2 of the Wisconsin Supreme Court justices may have agreed with him. Why isn't that in an accurate view of the instruction?
Sure. What I think the best way to understand the instruction, especially if you go through each paragraph of the pattern instruction, is the telling the jury not to put a thumb on the scale in favor of a guilty verdict or a not guilty verdict. So it says, do not give the presumption of innocence. A reasonable hypothesis consistent with innocence requires acquittal. But a reasonable doubt does not arise from guesswork or speculation or from sympathy. And then those final 2 sentences are the summary. While it is your duty to give the benefit of every reasonable doubt, don't put your thumb on the scale in favor of guilt. You are not to search for doubt. Don't put your thumb on the scale in favor of not guilty. And the instruction decides for, whether you may find it imprudent or not to leave the jury with just two negatives. It opts to give an affirmative direction to guide their deliberations. You are to search for the truth. And so that is why I do not think they're in tension. I think they're complementary. And at this trial, the truth of disputed factual issues was important. Was jailhouse informant Antoine Jackson telling the truth? Was Miguel Henderson's eyewitness identification truthful? And in fact, Mr. Williams presented, through other witnesses, an alternative account. He claimed he was shot somewhere else, not with a red Ford Expedition. And the jury had to decide whether that was truthful. So, as the trier of fact, the jury's job was to resolve these disputes, and it was perfectly reasonable to tell them to resolve those disputes as best they could with an eye on the truth.
If the jury was instructed, you are not to search for reasonable doubt, you are to search for the truth, would Williams be entitled to relief?
That would be a tougher case. I still don't think it would be an unreasonable application of Victor because of how Victor resolved the challenges to the moral certainty clause. Because Mr. Williams really makes similar challenges to the search for the truth, or the idea of not searching for doubt, searching for the truth, that the defendants in Victor lodged against moral certainty, that it invites a verdict without being convinced beyond a reasonable doubt, and that it invites consideration of factors outside of evidence. But it was not unreasonable. The same reasons that the Supreme Court in Victor rejected those challenges, I think, apply here. We have valid definitions of reasonable doubt alongside the use of truth. And in Victor, that was important because it couched moral certainty in the proper reasonable doubt definition.
So isn't that point, which is a point that Judge Rovner was eliciting a little bit earlier in our dialogue, isn't that the narrowest path through this? That the truth-searching language in and of itself may be problematic, but the analytical approach that the Supreme Court adopted in Victor is to take the challenge language in the context of the instruction as a whole. And when you do that here, it's hard to see, legal error by the Wisconsin Court of Appeals vis-a-vis Victor under the standard of 2254 D1.
I think
that's the narrowest path through it, and perhaps the Wisconsin Supreme Court will revisit the prudence of that last sentence, but in this particular case, it's here.
Correct. I absolutely agree. And I know also that the court was asking about the role of the search for truth sentence at the end of the instruction, and that is somewhat distinct from Victor. But I want to I omitted an instruction from my brief that I think is relevant to this question. It's a standard instruction. It came right after the curative instruction, page 75 of that transcript. And the judge told the jury, "Justice through trial by jury depends upon the willingness of each of you to seek the truth as to the facts and the same evidence presented to all of you, and to arrive at a verdict applying the rules of law as given in the instructions of the court." So that is one of the last things that the jury heard from the court. And that, I think, alleviates any concern, particularly under the 2254 standard we're with, that the search for the truth at the end of an otherwise valid instruction vitiated the rest of that instruction.
Would you like to go on to the prosecutor's comments?
I'm happy to, yes.
With which I seem to be obsessed, yes.
Yeah, I would like to address your question first about the forfeiture question. The state argued in direct appeal that the claim was forfeited, but the Court of Appeals did address the no answer comments on the merits along with the moldy ratty defense comment. And so the respondent here has treated it as addressed. But I think the fact that defense counsel did not object underscores that the comments were, although perhaps inartfully phrased, a proper response under Darden v. Wainwright. And that's really clear because the phrase that the prosecutor uses before his litany of no answer comments was, the thrust of defendant's argument is the police did a bad job. And then the no answers are not in response to Mr. Williams did not testify, but defense counsel's argument did not address these elements.
How exactly does telling a jury that Williams has no answer for certain pieces of circumstantial evidence and calling his defense old, moldy rather, and ratty, assure the jury that the police investigation was done thoroughly and properly? I mean, it seems to me that assuring a jury that the police investigation was done properly, or at least in line with the proper procedures, would have been a more appropriate way to respond to Williams' claims that the investigation had multiple shortcomings and that the comments the prosecutor made had very little indeed to do with the police investigation and much more to do with Williams' defense. I mean, I have a bit of a problem there.
I think I would say the prosecutor's comments were centered on the evidence presented at trial. And that evidence was obtained through the police investigation. The defense's argument was they did not do these other steps. And the prosecutor said, well, no, but they found this evidence of guilt that they're trying to ignore because it's not compatible with their argument. It's the no answer is not the ideal way of putting that.
I know.
Well, do you agree the no answer comments that Judge Rovner is referring to, that they were improper? You at least agree with that?
Yes.
If they were improper, then why weren't they burden shifting, or at the very
Well,
on a defendant's choice not to testify?
Well, first, because it was referring to the defendant's argument. Defense counsel had just made the argument and it was referring to that. So it was not referring to the defendant's decision not to testify. And it's also relevant that while the defendant did not testify, the defendant did present an alternative account through police officer witnesses that he was shot somewhere else, and that's why he ended up at the hospital with a gunshot wound and bloody camouflage pants. So there was contesting narratives at trial, and in order to respond to that alternative, or it's proper to respond to an alternative narrative and say it wasn't supported. And as it was, all that was supporting that he was shot at that alternative location was one anonymous report of a shooting. The police investigated the scene and found no ballistic evidence. And Mr. Jackson testified that Mr. Williams had told him that he directed his wife to take the gun and fire it off somewhere. So there were competing narratives, and given that, I don't think this can be an implicit suggestion that Mr. Williams should have testified. I think that perhaps the narrowest way to affirming on this case is to look at this court's decision in Bartlett v. Battaglia. It really is the same standard here about a prosecutor's improper comments on rebuttal regarding the reasonable doubt standard. And there are more mitigating circumstances here than in Bartlett. And this court affirmed the rejection of the claim in Bartlett too. Most specifically, I think there is a curative instruction here, and there was not in Bartlett. We also had the reasonable doubt standard and the defendant's right not to testify woven in throughout trial. Like, there was In voir dire, there was significant discussion about it that led the trial court to interject and clarify, look, the defense doesn't have to do anything. The court says that bluntly in the curative instruction. The defendant can just do nothing. If the state court in Bartlett did not unreasonably apply Darden v. Wainwright, then I think it follows that the state court in this case did not unreasonably apply Darden either. I have addressed everything I wish to say. I have 1:10 to answer any further questions you'd like. Then I would just simply ask this court to affirm.
Okay, very well, Mr. Conway. Mr. Andreg will give you that 1 minute I promised.
Thank you.
With regard, I want to try to address both issues quickly. With regard to the curative instruction, I think the cure was actually in a way worse than the illness, because that was when the court extended the idea of searching for the truth to actually making sure that your verdict represents the truth. Let your verdict speak the truth. That was the curative instruction. With regard to the issue of truthfulness and the idea that the jailhouse snitch, Antoine Jackson, that the issue was just whether is he telling the truth. Was he truthful or was he not truthful? You, the jury, should decide that. Or the real question, though, is do we have some doubt? Do we have some reasonable doubt about whether he was truthful? Because he came forward with his confession just after he was charged federally. His charges went federal. And finally, I just want to point out how this instruction sort of interplayed with these improper closing arguments, because defense counsel felt the need to try to take a preemptive strike on the instruction when he made his argument and predicted that the prosecutor would raise that in his closing rebuttal. The prosecutor did not do that. He then made all these improper remarks. But then the cure was the court gave the instruction which is worse than the prosecutor saying it. The court gave the instruction that defense counsel predicted the prosecutor would make. So thank you.
Okay, Mr. Andreg, thanks to you. Mr. Conway, again, thanks to you. We appreciate your advocacy. We'll take the appeal under advisement. Our second argument of the morning is in appeal number 23-1207, David Walton versus Ashley Nels. Okay, just hold on 1 second. Okay, is it Mr. Nahas?
Yes, Your Honor.
Okay, can you hear and see us okay remotely?
I can. Can you hear and see me okay?
We can, and you may begin when you're ready.
Good morning. May it please the court. My name is Newman Nahas. It is my honor to appear today before you on behalf of Mr. David Walton, the appellant. This appeal arises out of Mr. Walton's 1983 claim asserting that his Eighth Amendment rights were violated when, as an inmate, he was involved in a sexual relationship with a Pele, a prison employee who also happened to be his nurse and on whom he was dependent for special treats, including contraband drugs and a cell phone, not to mention medical care. The trial court granted summary judgment on the ground that the sexual conduct was consensual. We believe this court should reverse the trial court's ruling for two primary reasons. First, in light of evolving standards of decency, the time has come for this court to hold that inmates categorically lack the capacity to consent to sexual conduct with prison officials. And since the trial court's ruling assumed otherwise, this holding would require reversal. And secondly, if this court were not to hold that consent were impossible as a legal matter, this court should at the very least require that any attempt to establish consent as a factual matter be subject to a rebuttable presumption that would require the official to negate the existence of any factors of coercion, as other circuits have done. And doing that here, I'll argue, would also require reversal, since those typical factors were not negated. Now, first, the question of capacity.
Mr. Haas, can I ask you a question about the presumption framework that was adopted by the Ninth and Sixth Circuits?
Yes.
In application, isn't that presumption standard basically the same thing as the per se rule that you urge us to adopt, just in more specific circumstances? So, for example, the Ninth Circuit says that the presumption applies, and then the defendant has to provide that facts that there are no coercive factors, such as one of the things that the court talks about is where a prison official gives treats and whatnot to the prisoner. Well, if that's the case, doesn't that just become a per se rule in those circumstances?
So the way I understand it, is that what the per se rule would suggest is that there's a structural set of factors that globally undermine capacity consent. What the presumption would allow is for the exceptional case where, in those circumstances, those factors were absent. And so to answer your question, yes, if those factors are present, then yes, the effect of the presumption would be the same as the effect of the per se rule. But the difference, I think, would be in that the per se rule would contemplate the possibility of certain local situations that are the exception to the general rule. And in those circumstances, where, say, the relationship between the inmate and the official was very attenuated, maybe they were in different parts of the prison, and you might suggest in those circumstances that the structural reasons behind the per se rule don't apply, and so the presumption contemplates that possibility.
I would like to ask you on a kind of a different road for a second or two. The list that you mentioned, the contraband, after Walton and Nels were discovered, did anything occur to Walton that could be considered retribution or retaliation for the sexual activity between the two? And I'm not talking about, the time that he was investigated. I'm talking about when everything is done here between the two of them. For instance, could the transfer to the other institution be considered retribution or retaliation? For example, was that institution a higher security institution?
My understanding from the record is that other than that particular fact, there is nothing after they were found out that would suggest retribution. And what I would say too, with regard to the idea of retribution here, I don't think that the transfer is something that I could argue from the record constituted retribution in virtue of it kind of being a more difficult place to be. But my understanding is there is a disruptive component anytime there is any kind of transfer, and there is an injury that's associated with that. And so in some sense that it would be retributive independent of whether it's a more onerous environment to be in. It's just a different environment, and it kind of unsettles your familiar relationships and experiences. So I think that fact could ground an inference in front of a jury of some kind of injury that stemmed from.
Yeah. I also was wondering about something else. The district court refused to consider Walton's statement from his response to the defendant's proposed statement of fact, that he did not say no or stop, because it was not included in his complaint, his declaration, or as I recall, his deposition. On appeal, Nurse Niels is arguing that we should similarly refuse to consider Walton's statement. What's your response to that?
So my understanding is that there was a statement that he made in his response wherein he suggested that he was afraid of retribution.
Right.
And that was not in the sworn testimony that was attached to his summary judgment. My position on that is first that what was in the record included facts from which that conclusion could be inferred. And so, for example, one of the portions of the deposition that Apelli excerpts as being part of the summary judgment record that this court should limit itself to includes his statement. I'll pull that up in just 1 second. Yeah, so it's page 32 of the deposition, which is page 62 of Apelli's supplemental appendix. He says there, quote, "I wasn't looking to get myself, in any, And sorry, I cut it off here. And they ask him, why didn't you report? And he says, first, of course, that the female attention in that context is hard to turn down. But he also says, I wasn't looking to get her in any trouble, and I wasn't looking to get myself, in any. So I think there's sworn testimony that supports the idea that perhaps he was afraid to report. And then the second point I would make on this is I also think that it's somewhat immaterial because there are so many other factors that are not in dispute that would also support the reversal that we're requesting under a presumption of non-consent rule, or under the per se rule, this wouldn't matter.
Yeah. Huh. You see, yeah, well, I think retaliation in that atmosphere is a really onerous consideration.
Mr. Nahas, can I ask you what I intend is a bit of a line drawing question that maybe you could help us with? How do you recommend that courts define sexual conduct for purposes of the application of either rule, whether it's a presumption or a per se rule?
Yeah, I was kind of grappling with this because I think it's sort of the baldness paradox, right? Where how many hairs do you have to lose to go from having a full head of hair to being bald? The exact transition is kind of vague and difficult. But we know that there's Mr. Clean and then there's Fabio, and so it's a spectrum. Holloway identifies kind of at one end of the spectrum, incidental, inadvertent, one-off touching that is inappropriate but doesn't necessarily reach the level of sexual conduct that implicates the Eighth Amendment. What kind of sharp principle can I suggest? I don't know that I can. I think it's one of those things that maybe should go to the jury, that it's part of why it's inappropriate to dismiss this as a matter of law, is that the boundaries of some of the categories that inform this inquiry are not entirely amenable to kind of like a sharp rule. But in terms of what we would suggest is that anything that is sexual in that is ongoing, that involves the genitalia. I mean, I think there are some clear-cut cases, and our case, I think, would fall under more of the straightforward portion of the spectrum, where I don't think that.
Yeah, I mean, I agree with you on these facts that question is not squarely before us. But if we were to agree with either of your positions, your primary position or your secondary position, I would think of the district courts in our circuit would be quite interested in how that term is defined, given the range of conduct that could, underlie a 1983 Eighth Amendment claim.
Right. And one suggestion would be to use the definition promulgated by the Department of Justice in their in the standards reflecting the PREA Act, right? So there, sexual abuse is defined, and it involves, uncovering genitalia, buttocks, breast, voyeurism. It has quite a, I think, useful set of guidelines.
When she touched his left arm, okay, would you include that?
I think in and of itself, no.
When
An
she-
isolated incident, if that was all that happened between them, no.
When she grabbed his shirt,
Under Holloway, probably, if that's all we had, probably no. But it would be the accumulation of further conduct and kissing and
Do you
some of
see
the other
any-
conduct.
Do you see any problem if we were to say, for example, conduct that is undertaken for purposes of sexual gratification? Now, you might say, what does that mean that way? But going back to the first point that you made about juries are capable of being instructed in finding facts and looking at all kinds of fact patterns, would that suffice? Or is,
I think
is
you-
something like that too general in your view?
I think it's you need two elements. I think one is the purpose and the other is the objective. The intrinsic character of the act has to coincide with what our human conventions of sexuality would recognize as an instance of sexual conduct, in addition to the purposive component.
Yeah.
So in order, I think, to implicate the Eighth Amendment, you have to have that culpable state of mind, which is what the purpose inquiry would get us at. But what you do has to also fall under what we reasonably would recognize as an instance of sexual conduct.
Yeah, that's what I thought you might. I appreciate your answer, and it's that second part that is the hardest part of this.
In the way I think about it, right, is that we have vagueness in a lot of moral categories. And that's kind of just why I think the Supreme Court in Atkins suggests, hey, let's look at what the legislative enactments tell us and see if we can glean from them ways to operationalize vague boundaries. But I think the existence of kind of edge cases, though, shouldn't necessarily cause us too much pause about having rules that'll at least encompass some of the central cases.
Okay.
Mr. Nahas, can I ask you a question? One of the disputes that the parties have is about whether or not we can consider the deposition excerpts that were not submitted to the district court in the underlying motion for summary judgment. I understand this is not a unique situation for appellate lawyers when they are looking at a case on appeal. But typically, we limit ourselves to what the district court had to consider. And while some of the excerpts that you point out, I think, could be supportive of your client's assertions, can you tell us how we can go about, what is your best argument for how we can go about considering those additional deposition excerpts that you have submitted on appeal?
So my impression here is that there's kind of two different issues. One is if we're evaluating whether the trial court, based on the record that the trial court was confronted with, right, whether if we're trying to assign error to the trial court based on that record, then no, I don't think the additional excerpts are appropriate for that inquiry. However, I think that the Court of Appeals, though, can look at the entire record below to consider things, for example, like, hey, is this reversible error? Is this harmless error?
But
And
I guess-
I think what
I guess my question is,
right.
we looked to see if the record below anywhere had these transcript excerpts, say in response to a motion to compel or anywhere else in the record. But we couldn't find a place in the docket, in the whole of the district court's docket, where these excerpts were submitted. And so I guess I'm a bit wary of going beyond not only the summary judgment record, but the actual, the entire record that the district court had, and wondered what would be your response to that.
I think our response to that would be that in terms of the relief that we're requesting, we do not need to go beyond the record that is encompassed by the record on summary judgment and the docket. To the extent that the deposition excerpts go beyond that, I don't think that they are essential in any way to the relief that we're requesting. I mean, we're relying, right, in the first instance on legislative facts, right, for our per se rule. And for the second, request and the alternative, we are not in any way really I mean, I think the only issue that required going beyond the record on summary judgment was some of the details concerning his theory of why he feared retribution. But I think that is something that it also follows from what was in the record, both in terms of what was before the trial court on summary judgment and also what was elsewhere in the docket. But I mean, I think for purposes of our first point, we're looking at legislative facts. And for purposes of our second point, the rebuttable presumption, his dependence on the quintessential carrots that the Ninth Circuit and the Sixth Circuit has identified as undermining the capacity to meaningfully consent, I don't think those are really even in dispute. I mean, I think their response is that, hey, he conceded enjoyment. He was happy, right? And to me, that is a legal question for this court is, hey, if there's a dispute about the capacity to consent, and if there's a reason to say in these circumstances capacity is vitiated, well, then we're not going to credit an expression of consent. And I think that's the real argument here, which I don't think in any way really turns on some of these technical questions about the record, and I regret that we went past the record for background. I think it distracts from the real questions, which I think turn on legislative facts and questions that are squarely in the record.
Thank you.
Okay, Mr. Nahas, we'll give you a minute in rebuttal, given the dialogue we've had here. Let's hear from, is it Mr. Sheepior? Sepier. Good morning to you.
Good morning to you. Thank you, Your Honors. May it please the court, my name is Attorney Vincent Sepier. I represent the defendant appellee, Ashley Nels. To begin with, I want to make sure that the court sort of understands our position on the facts of the case. My client absolutely 100% denies the allegations that the plaintiff made in this case. But I went and I took his deposition, and it was based on his own deposition testimony that we moved on summary judgment. Even if the court accepts everything that he says, this does not rise to the level of an Eighth Amendment violation. And I also think it's important to start with what brings us here. This is a civil claim under 1983 for an alleged violation of Mr. Walton's Eighth Amendment constitutional right to be free from cruel and unusual punishment. When we talk about consent and the criminal statutes that exist, and even this evolving standard of decency, I think that there is a difference between the criminal statutes on the books and the purpose of a civil case, a civil claim. When we talk about the elements that Mr. Walton has to prove for an Eighth Amendment claim, there's both the objective prong and the subjective prong. And some of what I think the question was going back to the purpose of sexual gratification, I think goes to the subjective prong. But the cases that we've relied on focus more on the objective prong, whether he can prove an injury. And so, especially if we go back and we look at this framework of a presumption of non-consent adopted by the Sixth and Ninth Circuits, it turns that burden of proof on its head, because a plaintiff bringing a 1983 claim for a constitutional violation has the burden of proving the objective element that he sustained an injury, that there was.
If you've argued, and you are arguing, that the court should not adopt a presumption
Correct.
of consent because it would impermissibly shift the burden of proof from plaintiffs to defendants. But there are other areas of the law in which we regularly apply presumptions. For example, in Title VII cases, there's McDonnell-Douglas balancing framework. Our court has already recognized the enormous power disparity in the confinement context. Why then should we not adopt a presumption of non-consent, given that enormous power disparity?
Yes, I think for two reasons actually. One, I think it actually goes back to the point that was discussed earlier of the various levels of what sexual abuse or harassment would mean in the context of a penal institution. That if all the plaintiff has to do is allege that there was some sexual contact, and then the burden is shifted to the defense to disprove these other elements of coercion and control, I think it would present a problem for district courts because, as your honors have sort of addressed earlier, in this situation where the fact pattern that we're discussing is that there was a voluntary free sexual relationship, these one fact-dependent elements of contraband and snacks are usually going to be present there. They're present in many of the cases that other district courts and the other four circuits who have addressed this issue have looked at. That if when you're alleging that there's going to be a voluntary sexual relationship, oftentimes there's going to be these types of fact-dependent favors that have been discussed. And so I think that adopting the presumption here would put an enormous burden on the defendant, where the plaintiff doesn't have to prove really the elements of his claim. The other thing I think goes to when the appellant talks about the evolving standards of decency and the criminal statutes that have been adopted both by the federal court as well as the states. The purpose of those statutes is to deter such behavior, to punish prison official if they engage in these types of relationships. But I think adopting either a bright line rule or a presumption encourages the behavior. It encourages the behavior from the perspective of a prisoner, that they either know that there's a bright line rule, and we see that even in this case where the appellant says, doesn't matter if I liked it, if I enjoyed it, if I wanted it, can't legally consent, and so just the fact that there was a sexual relationship, I'm entitled to relief under 1983. But also under the presumption, it creates that same encouragement of this type of behavior. It gives them a motive to profit, to seek out these types of relationships. And if there's a presumption that the defendant, that the prison official is going to have to overcome, I also think that it runs the risk of deterring prison officials from reporting behavior that they could be concerned, okay, now I need to defend myself.
Well, isn't the answer to that prison officials just shouldn't engage in any sort of sexual conduct with prisoners.
I-
So I guess I don't really see, it seems like the criminal statutes and whatnot are evidence of, or indications that this is activity that the state legislatures do not think is appropriate to the extent that it's criminal. My question about the presumption framework is a little bit different, which is typically when we think of consent, we think of consent as an affirmative defense. Here we're dealing with an Eighth Amendment claim. And so in the context of a 1983 case, does the defendant have the burden to prove consent, or does the plaintiff have the burden to prove non-consent? Because I think that matters when we're talking about any sort of presumption or burden shifting.
Yeah, to address your first question, we are not asking the court to condone this behavior in any way. It's inappropriate, and I agree with you, and I agree with the criminal laws that are on the books. But that leads into your second question that, no, it's not a defense. There's been a dozen cases throughout the country, district courts, and then the 4 circuits that have looked at this. Some of them have sort of talked about it in that sense of the defense of consent, but it's not a defense. It's not an affirmative defense that it was consensual. Rather, it goes to that objective prong. Did the plaintiff in the case, the appellant, did he sustain an injury? Was there harm that he sustained such that he can prove the objective element of his Eighth Amendment claim? So no, I don't believe it's a defense, and I don't think any court has looked at that other than the 6th and 9th, where they talked about it being a presumption of overcoming these coercive factors that they look at. But I think that the decisions from the 8th and 10th Circuit are a less problematic route, where they say we're not going to adopt a per se rule. We're not going to. They did not adopt this presumption of non-consent, but rather they look at this as this is a 1983 claim for an alleged violation of your rights. You have to prove an objective prongs. Can you do that? They focus on the first one, that there was an injury, an unnecessary and wanton infliction of pain. I mean, that's what the plaintiff needs to prove in a 1983 case.
Mr. CPR, in a case like this, requires you to get back, as this dialogue is showing, to some of the first principles in the Eighth Amendment area, at least under the test that the Supreme Court has given us. I want to ask you hypothetically, keep all facts the same, but suppose Mr. Walton at the time of the conduct was 17. How would the legal analysis change in your view, if at all?
It wouldn't. And that's because, again, it goes to a civil claim. And we addressed that in our brief. And this case, this court has recently addressed that, I believe, in Buell. And it goes back to the fact that under criminal law in Wisconsin, sexual contact with a minor, although when it's 17, there's some more nuanced rules. But if we're talking about a sexual contact with a minor, consent is not a defense. But where it's sexual assault in criminal cases, it's battery in the civil context. And at least in Wisconsin, you have to prove that there was sexual contact and that it was not consensual.
Okay, so just to try to flesh out some of the principles, assume Mr. Walton was 12. Okay, at what point would the legal analysis change, in which I'm interested in is why? The state law would become more clear, right, as far as what community decency standards are in prohibiting sexual conduct with children. How do you analyze it for purposes of the Eighth Amendment? Because you would never get to the point, I don't think, under Supreme Court jurisprudence of saying that Eighth Amendment standards are parallel with, synonymous with state criminal law standards.
Correct.
So what's the principle that teases this out?
Well, it's often the courts, and what the appellant asked this court to do here is where they're asking them to consider the criminal statutes. 1983 is not meant to constitutionalize criminal law or even all tortious conduct. Not all tortious conduct violates the Constitution. Not all criminal law violates the Constitution. And so here it would be that when a plaintiff brings a civil claim, whether they're a minor or whether they're a prisoner, they have the burden of proving the elements of their claim that they were harmed. The fact that they were a minor is not a per se conclusion that it was unconstitutional. And so I think it goes to a fact question.
We know that the justices have accepted some per se conclusions with juveniles, right?
Yes, and I think that going back to this court's decision last year from Buell, when it's a civil claim, I think that the court is giving too much power to the criminal statutes, and it goes back to then, if there were facts in the record that would suggest there's a genuine issue of material dispute, a factual dispute as to whether there was an injury, whether there was harm, that would preclude summary judgment.
Would you agree that you said, looking at the factual record, that the relationship between a particular prison official and a particular inmate, for example, if the official was in charge of providing medical care, or if the official was in charge of supervision and had the power to discipline, that those factors that are specific to the case, that those factors are substantial factors that a district court should weigh on summary judgment?
Well, when you say substantial factors, I think that they are factors that can be considered by a fact finder, and I think that if there's dispute of fact, that's something that the district court should look at. Just like any other.
And did the district court do that here?
Yes, I think the district court looked at what was on the record, what was in his sworn deposition testimony.
No, but did this district court consider the authority that the defendant that you had over the plaintiff? Because when I looked at the summary judgment order, I had a hard time finding any particular discussion of the relationship between the two.
No, and I would say that was not raised at the district court level. That was first raised on.
But you agree that that's something that, given the facts, can be relevant to the particular situation and to the issue of consent or non-consent?
It could be relevant. I don't think it's relevant in this case based on the plaintiff's own, the appellant's own sworn testimony.
The district court focused almost exclusively on Walton's statements that he enjoyed the contact or the contact. I have two questions. One is it Ms. Nail's view that enjoying sexual contact demonstrates consent? And is it not true that consent must be obtained before any enjoyment-inducing activity commences?
First, I would say that was, I don't believe the sole reasoning of the district court. I think that. I
didn't say so. I said almost exclusively.
Okay. I think that he testified that from his perspective, he thought it was factually consensual, that he was a willing participant. But again, it goes back to this issue of consent, and I would say that it would be more reasonably framed as it goes to whether he was sustained a harm. What is his harm? What is his injury? And so then when it goes to the consent before, my answer would be the same, is can he prove a harm? Can he prove an injury on these facts? But also that I think thank you.
The fact that she was the staff member on whom Walton relied to obtain medication in order, to keep living, so to speak, wouldn't that be enough to create a genuine dispute of material fact?
I think that would then create a per se rule, a bright line rule, because that's what we're always discussing as a prisoner and a prison official. And if we're going to say that because there's this control in the environment, that would show a lack of consent, it would be a bright line rule that none of the circuit courts have adopted.
Why do you think it would be a bright line rule as opposed to just an assessment of the totality of facts and circumstances? So if you go back to the question that Judge Lee posed about a gift or something like that, you would have to size that up in the whole of the fact pattern. So if you're talking about a relationship that went on for years and there was one token gift at the outset of it, that way it may not inform the analysis that much. If there were multiple gifts or pills being given on the side or some of these other, it may that way. But why can't that just be worked out in each individual case?
Well, I agree with that, and I think that is how it should be worked out. And I think that here the district court found that no reasonable jury could find, based on the record, that Mr. Walton's Eighth Amendment rights were violated.
I guess I'm looking at the order again, and I just can't find a place in the order where the district court considers that, other than saying that she was a nurse. But if a district court should weigh those things as a relevant factor, considering the totality of circumstances, is this a situation where we have to send it back so the district court can do that?
No, I think that those are certainly factors that can be considered when they're presented to the district court, when it's argued from the appellant side, plaintiff side at the district court level. It wasn't actually consensual. I wasn't a willing participant because I was afraid of this.
But the district court knew that the defendant was a nurse and the defendant was providing medical attention to Mr. Walton, right? That was part of the record, certainly.
Yes.
And that's the type of discussion I'm looking for in the district court's opinion and having a difficult time finding.
And that wasn't analyzed by the district court level. I think because of what the appellant said in his deposition transcript. When you read the transcript, I mean, the district court used some strong words, that it just felt that there was no reasonable jury that could support it.
Okay, thank you.
Okay, thank you, Mr. CPR. Appreciate it very much.
Thank you.
Okay, Mr. Nahas, we'll give you, we went on a little bit there. We'll give you 2 minutes for rebuttal.
Thank you very much. The first point I want to address is the issue of incentives. Appellee kind of raises the specter that a per se rule or a presumption of non-consent would have incentives that would be counter the policy here that I'm arguing for. It would incentivize more conduct. I don't think that's right. I think the real point to think about is if we have a rule that says that consent is possible, what that incentivizes, right, is no sexual conduct with inmates who don't want it, right? But it's neutral with respect to inmates who express that they're okay with it. And I think that's inconsistent, that posture in terms of the incentives that the rule would create, that seems to me wildly out of line with the incentives that are reflected in legislative enactments. The second point I want to speak to quickly is the criminal versus civil. I think this kind of flips the law on its head. The fact that our standards of decency are so offended at the thought that there could be consent in this context that we're willing to criminalize the conduct, to me, that's all the more reason that our standards of decency wouldn't allow it as a defense in the context of the civil inquiry. And then the other thing to note is that, look, the common law of torts doesn't expressly tell the courts they have to look at legislative enactments, whereas the Eighth Amendment does. The third thing I wanted to address was I think that there's a category mistake that kind of runs through the district court's reasoning. I think the district court latches on to the expression of enjoyment and consent, but that presupposes that the expression was capable, right? That there was capacity. And the other thing I want to speak to is I think that the question of harm and injury, that really may go to quantification of damages. And there's certainly some of these outlier cases that appellee's worried about. That's something that can be presented to the jury, and perhaps it will result in nominal or limited damages. But I don't think that speaks to whether the first question of capacity consent is addressed. And so for these reasons, we would respectfully request that this court hold, consistent with evolving standards of decency, that the time has come to recognize the inherently coercive context of incarceration requires at the very least a presumption of non-consent, if not a per se rule.
Okay, Mr. Nahas, thanks to you. Mr. C. Pierre, thanks to you again. Mr. Nahas, I know that the court appointed you and your firm to represent Mr. Walton. We very much appreciate you accepting the appointment, the quality of your advocacy, and we'll take the appeal under advisement. Thank you.
Thank you.
Okay,
It's
the
an
court will
honor and a
stand
pleasure.
in brief recess for 10 minutes. We'll continue with argument in our third case of the morning, appeal number 232851, Lyra Hernandez versus the City of Peoria. Good morning.
Good morning.
Good morning. My name is Kelly Olivier, and I represent the appellant, Lyra Hernandez, for the estate of Louis Cruz, who was shot and killed by Peoria Police Department officer Ryan Eisenhart on July 19, 2018. Eisenhart and the City of Peoria's theory of this case is that Eisenhart appropriately used deadly force when, in less than 1 second, Louis brandished a weapon, racked it, and pointed it at Eisenhart's partner, Nicholas Mason. Appellant's theory is the opposite. Not only are those actions impossible to have accomplished in the less than 1 second, at the time that Louis was shot, he was turning to his left to comply with Eisenhart's command to stop. Louis never brandished a weapon, and he never threatened anyone, let alone Mason. Importantly, at summary judgment, the district court noted that there were substantial discrepancies between Eisenhart's and Mason's versions of events, and that the dash cam video of the incident contradicted both Eisenhart's and Mason's testimony. To prove the case at trial, appellant sought to present evidence that would allow the jury to have a reasoned evaluation of the facts, and to focus the jury's query on the only relevant inquiry. Did Eisenhart use excessive force when he made the split-second decision to shoot
Ms.
Louis?
Olivier, I'm glad you started like this, because one impression I took away from your briefs a little bit is that you present 4 alleged errors, right? But there's a flavor of the argument that seems like you're challenging the sufficiency of the verdict. But that's not before us, is it?
No, it is not. And I would like to point out that we are specifically alleging a total of 6 evidentiary errors, but they do fall into 2 separate buckets. So the first bucket would be those 4 errors that you're referencing, which is the evidence that was improperly admitted. The second bucket would be the evidence that we're arguing was improperly excluded. And the cumulative effect of those errors essentially rendered the trial fundamentally unfair to appellant.
I'd like to talk to you, please, about the bifurcation, because the plaintiff refused bifurcation of the trial, of course, because she wished to present evidence about Mr. Cruz's character as a father and a brother to the jury. Under bifurcation, this evidence would have been available to the jury, of course, at the damages phase, but not at the liability phase. How do you think Cruz's character as a father and a brother is relevant to liability? And if it isn't, then why didn't the plaintiff not create any prejudice herself by refusing the district court's offer of bifurcation? I have been really puzzling over that.
Ultimately, and the district court did note this in the motion for summary judgment and throughout the trial, this was a case that turned on the credibility of the witnesses, Eisenhart, Mason, and the team members. And if there had been no testimony proffered on behalf of Louis Cruz, the jury would have certainly gotten 0 flavor for Louis. I would also note that
But the plaintiff's counsel never explored what they would be able to say about Mr. Cruz, because presumably the jury would need some background about Mr. Cruz. And what puzzled me, along the lines of what Judge Rovner was saying, is that there was no attempt by plaintiffs to even explore that option. Judge, what can we what can we say about Mr. Cruz? Can we say that he's a father? Can we say that he's, has a partner, to provide at least some general background as to Mr. Cruz? And I'm surprised that there's nothing like that here.
Well, I would note that with respect to the specific pieces of evidence that we're arguing should not have been included, it did go to Mr. Cruz's fatherhood, right? The trial court admitted into evidence that he was incarcerated at the time of his child's birth.
I guess my point is, I think if there was something in the record where the plaintiff's counsel said, Judge, we would agree to bifurcate, but only if you allowed this type of testimony in a liability phase. And the parties explored that, and then the plaintiff said, okay, well, no, that because we need this information, even for liability, then that would be one matter. But I don't see any sort of discussion like that here.
I would note that at the outset, plaintiff's appellants here today filed motion in limine number 1, and that was a broad motion seeking to bar all of Louis' past criminal history, bad acts, and character evidence. So what we're talking about in this first bucket of evidence, which includes not just the bad evidence about his fatherhood and his criminal history, but also discusses the 49 messages, was all dealt with in one fell swoop. So we brought our motion in limine number 1, seeking to bar all of that evidence as irrelevant. And at the very first pretrial conference, the district court made it clear the 49 messages were coming in, and thereafter it was one thing after another. So the trial team at that point was making certain adaptations based upon the court's ruling. I would note that we attempted to revisit this issue with the trial court again and again. As you noted, that he did offer bifurcation. But ultimately, knowing that the 49 messages were going to be coming in, this jury was going to be hearing this bad character, bad acts evidence, appellant wanted to be able to present and set forth the depiction of Louis, showing that he was a good father. And unfortunately, by showing that he was a good father, that's where all this impermissible other evidence came in.
Can you, just in the limited time we have, one of the arguments that you make in your brief relates to, I think she's a member of the Illinois State Police, forensic team.
Yes.
This is Jennifer McRitchie.
Yes.
Can you explain the testimony? I have a hard time from the briefing understanding how she was going to fit into your side of the case and what she was going to say or not say.
Certainly. Jennifer McRitchie was an Illinois State Police forensic scientist who created a conversation record, which was a business record essentially, of a major case incident review that took place 1 week after the shooting, at which she and others, including other laypersons, were present. In it, she noted what the Illinois State Police and the others present at this major case incident review were told about the underlying facts of the shooting. It's notable that at this major case incident review, her conversation record does not document that the offender turned and brandished a gun. It doesn't document that the offender racked a gun. It doesn't document the offender pointed the gun. It does not even note that the shooting officer was defending his partner at the time. All it merely stated was that ISP was investigating that the offender turned and reached for something at his waist, and that the officer fired in self-defense, killing the offender, and that ISP would be investigating whether a gun was visible/used. Appellant's position is that is a yet another inconsistent and contradictory version of events from what Eisenhardt's testimony and the other officer's testimony was at trial.
So would the idea have been that you called McRitchie to the stand and said, did you attend this meeting? What do you remember being said and not said?
Correct.
And wouldn't that be hearsay?
Yes, but I think that we would, to the extent that she was present and this was information told to her, would also come in under impeachment by contradiction. Once again, this is a situation where Louis was deceased. He did not have a voice in that courtroom. So this actually with McRitchie and also Shaquille Alexander.
Impeached her role in the investigation, or impeached the broader local police department's investigation? Or I'm sorry, the Illinois State Police investigation.
It would impeach the version of events that was being proffered by the city and by the team members and by Eisenhardt and Mason at trial.
Would I be wrong if I thought that the plaintiff offered no proof that McRitchie's conversation report was a reliable summary of all information that the police had, or even that she obtained the information from the police?
In our proffer and in our motion for reconsideration, we did note that we had spoken with McRitchie and that she had indicated to us that a conversation record is something that she and her practice as a forensic scientist that attends these major case incident reviews on a regular basis, the conversation record is something that she creates contemporaneously with these major case incident reviews. It's important that it's accurate. It's important that it, to the extent that she's documenting what is told, what she is told then dictates the crime lab's next steps in the Illinois State Police's investigation.
Well, I guess what I'm puzzled about is that, as Judge Scudder noted, I'm not clear who this testimony would be impeaching and how it would come in. I think as a business record, you also need to establish that the people from whom she got the information had personal knowledge of the events. And here, I don't see anything that you've provided that would indicate that anyone that attended this meeting would have personal knowledge. So, for example, Officer Eisenhardt wasn't there, and it's unclear whether anyone from the Peoria Police Department was there who would have spoken, I suppose, to the officers. And it just seems like it's so attenuated for impeachment evidence.
Understood, but at the same time, I think that would be important for cross-examination to a certain extent, but nevertheless,
But you're not. Impeachment doesn't come in just to impeach a theory of the case. Impeachment comes in to impeach testimony, right? And so here, the only testimony that you would be trying to impeach are the ones of the particular officers on the scene, and this impeachment evidence, if you want to call it that, I wonder if you can, if is there a more direct link that you can make between the officers themselves and this conversation record?
I think to the extent that at the major case incident review, in theory, they would have had access to the police reports of these officers, yet this conversation record still documents that they were investigating whether a gun was visible, not whether officers...
But for example, if someone had reviewed all the police record and attended the meeting, right, someone from ISP, and then they just recollected it incorrectly, right? Like, how wouldn't that kind of undermine the impeachment value of the conversation record, and how would the defendants get into that then?
Respectfully, I would state that the conversation record, to the extent that this major case incident review is so integral to the investigation and the testing that the Illinois State Police were going to be performing on the actual gun that was recovered at the scene, and with respect to all of the physical evidence, that for this information to be inaccurate would be a huge issue.
But also, Ms. McRitchie wasn't even the one responsible for securing the swabs, right, the samples. That was Mr. LeMasters, right?
Correct.
And so, in your brief, you talk about how this meeting will set kind of the protocol for what testing will be done, but the decision whether or not to swab the area of the gun that might have been touched, the breech of the gun, that was already made by Mr. LeMasters after he was already told what the officers had told him, right?
That decision had already been made, but McRitchie could have also made the decision that despite that swabbing not having occurred, it could still have occurred at that juncture. That's one of the reasons why the major case incident review is so important. It's kind of a check and balance off of the investigation that already took place at the scene. So to the extent if she had been informed that the gun had been racked, the gun was in still such a condition that she could have made that determination, you know what, this is a question that we still have to potentially explore, let's make that swab. So that's again why it's so disturbing that this information was incorrect within that conversation record. I would further note that, as set forth in our brief, we sought forth to introduce McRitchie's testimony, but also the testimony of Shaquille Alexander. We did seek a pretrial ruling regarding Alexander's statement, and it is true that at that time we did not raise the Rule 803 exception, but I would point out that the court used this circuit's decision in United States versus Moore, where this circuit explicitly found that the Rule 807 exception is particularly apt where a statement bears the markers of reliability that are equivalent to those found in statements specifically covered by Rule 803 or 804. And as we set forth in our brief, Mr. Alexander's statement falls neatly within the Rule 803 exception, and the analysis is one and the same. It's because of the cumulative effect of the district court's rulings, both individually and as a whole, but the cumulative effect especially made it such that appellant was essentially fighting this trial with one hand tied behind her back, and we're seeking an opportunity for the judgment to be vacated and remanded so we could fight with both hands.
Okay, thank you. We'll give you a minute on rebuttal.
Thank you.
Mr. Sotos, good morning.
Counsel, may it please the court, my name is Tom Sotos. I represent the defendant appellees in this matter, the city of Peoria, and Officer Ryan Eisenhart, who will be asking the court to affirm the jury verdict in this case. Briefly, to orient the court, kind of where we're at, why we're here. In August of 2022, after more than 3 years of litigation, the district court denied Officer Eisenhart's motion for summary judgment on the excessive force claim against him, deciding that a jury of his peers should decide the case. After 3.5 days of testimony, over a 5-day trial, the jurors retired for deliberations, they weighed the evidence, and after 3 hours and 20 minutes, they returned a verdict unanimously in favor of Officer Eisenhart. And now we're here, and we're litigating a series of appellate issues born not out of the summary judgment ruling, and frankly not particularly out of the verdict, but almost exclusively out of strategic choices or missteps that plaintiff's counsel made in the workup of the evidence that was later admitted at trial. I would like to go directly to the issue of Ms. McRitchie. The focus of the court's question during counsel's argument was on that issue, to try to be as clear as possible. The major case review that is the focus of from where Ms. McRitchie's testimony would have come from. The only people to this date that we know for certain were at the major case review were Ms. McRitchie and Jerry Brady, who was the state's attorney at Peoria County at the time. There was an agreement between the parties not to introduce any evidence flowing from Jerry Brady's investigations into the trial. The parties agreed to that in a motion to eliminate file with the court that's mentioned in our brief. There has yet to be an explanation as to how any of the evidence Ms. McRitchie could have offered would have come in circumvention of that agreement, and that agreement was never offered to be withdrawn during the course of the trial proceedings. In addition, judges raised on multiple occasions some basic rules of evidence. We note in our brief that the initial ruling on Ms. McRitchie flowed from her disclosure late in the course of the litigation as an expert. I would note that plaintiff never disclosed Ms. McRitchie as a witness, either as an expert or as a fact witness. This despite defense counsel having disclosed Mr. Renaud and Mr. Johnson, who were essentially Ms. McRitchie's peers with the Illinois State Police. They were responsible for fingerprint analysis and weapons analysis. Ms. McRitchie did DNA analysis. Ms. McRitchie was never disclosed. Those two individuals were. I raise all that to note that they could have worked up a record had they desired to use Ms. McRitchie to demonstrate how her testimony would, as Judge Lee noted on numerous occasions, impeaches Officer Eisenhart's testimony in any way, shape, or form. That record wasn't made, and in our brief we note the trial court's eventual ruling, when plaintiff moved to reconsider the exclusion on the grounds that she was disclosed late and her testimony was expert in nature, the court ultimately found that it wasn't impeaching testimony, which was the purpose that plaintiff's counsel identified Ms. McRitchie would be testifying to. That issue of impeachment, the ultimate ruling, which we raise in our response brief, that goes unresponded to in the reply. So respectfully, the ultimate ruling on Ms. McRitchie is that she couldn't come in because they couldn't demonstrate how she would impeach Officer Eisenhart. That issue hasn't been addressed in the papers. We would argue that it's waived since it's not addressed in the reply.
Can I just rewind you for
Absolutely.
5 seconds on the? I may have missed it. Where did you make this point about this in limine ruling?
We noted in the brief. We do not argue it extensively.
You did note
it
it in
is
your brief?
noted in the response brief that Mr. Brady. I don't have the page. I can find
It's
it.
all right. I can find it. I just don't remember reading it, but it's probably there.
His name is Jerry Brady. Your Honor, it may well be in a footnote. This was not a major feature of the argument.
Okay,
But
all right.
I want to ensure the court that it is in the brief and in the record. And I can do this with some quickness. there was a agreed motion to bar Jerry Brady evidence. That is docket number 67 on the record, where the parties filed the joint motion agreeing to bar the evidence from Mr. Brady. And again, he's the only other person that we know was at the major case review. A final point on the major case review. There are a number of representations in counsel's brief, and I would simply caution the court to be very wary of accepting certain representations where they aren't based on the evidence. There are a number of representations that the Peoria Police Department must have been at the major case review. There's nothing in the record to support that, and respectfully, it defies some common sense understandings of law enforcement and investigations. The major case review had Illinois State Police and the Peoria County State's Attorney reviewing the shooting. They were looking at the Peoria Police Department's actions. I don't believe it would make particular sense that the Peoria Police Department would be at this review, and there's no evidence in the record that they were. So any representation to that extent, it's not in the record.
I want to ask you something factual, please. I was unable to get hold of the video, and the plaintiff maintains that the words "drop the gun" cannot be heard on the video. Is that correct?
We would dispute that representation. We believe that it can be heard. The audio it requires some focus to listen, and I'm not sure why that isn't in the record. I probably weren't responsible for preparing the record here. It's 47-9. It was an attachment to the summary judgment briefing, and it was offered at trial as an exhibit. I can't remember which exhibit it was, but that video evidence should be made available to court. It was a feature presentation of the trial, so that would be my position, Your Honor.
And I'd like to ask you about the drug charge. You know, a pending charge doesn't mean that an individual has been found guilty of a crime or that they would serve any jail time related to that charge. Given that, what relevance did Cruz's pending drug charge have as to the question of damages?
Absolutely, Judge. I think that this question is effectively resolved by this court's decision in Kobach. This was a loss of society case vis-a-vis the issue of damages. So the question is, the jury's trying to adjudicate, quantify the loss of society experienced by Mr. Cruz's daughters. That's the question. And part and parcel to that calculation is the fact that Mr. Cruz is no longer around. He was tragically killed in this event. However, and I appreciate the court's note that a pending charge is not a conviction. However, it raises the possibility that Mr. Cruz would have been unavailable to his daughters because of a prison sentence that would have resulted from that charge. And in addition, Kobach teaches that when damages are part of the trial, and the plaintiff paints out in this case, the decedent, in somewhat saintly terms, there was quite a bit of emotional testimony from his family about the kind of father that he was, the kind of person that he was. They are entitled to present that evidence in connection with damages. We not only are entitled to, but we are all but required to put on any evidence we have to rebut that notion. That's what Kobach teaches, where this court actually reversed the exclusion of this sort of evidence. Respectfully, we think that if the trial court had gone the other way and had excluded this evidence at the trial level, and in a hypothetical scenario, the verdict had gone against us, we would have had an extremely strong appeal for a new trial on damages, because this is the kind of evidence that Kobach teaches has to come in.
And you say that against the background of the way this proceeded, and only the way it proceeded, with the plaintiff refusing bifurcation.
I apologize, I didn't hear the beginning of your question.
Yeah, you that argument that you're making has to be taken against the backdrop of the way the case proceeded, where the plaintiff declined the invitation to bifurcate. Right. The analysis, I think, could be altogether different if the plaintiff said, "Yes, I want to bifurcate liability and damages," because I don't want that testimony coming in at the liability phase. It has nothing to do with this.
I appreciate that, Judge, and I agree. However, the plaintiff didn't do that here.
No. I know I joined Judge Rovner. I have no idea why, but that's the way the case was litigated, and those decisions aren't our decisions to make. So the case comes to us on a record where the plaintiff declined an invitation to bifurcate the trial.
Right. Yeah, no, I understand that. And Cobage was a joint trial on liability and damages. And I would simply note that where that is the circumstance, and particularly where it's the result of a choice the trial counsel makes, the defendants are entitled, virtually required, to address two separate legal regimes, if you will. One is liability, one is damages. And I understand that bad evidence on damages for either party is also bad, likely on the issue of liability. We would submit it was the same for us. Painting Mr. Cruz out to be a particularly, I keep using the word saintly, if there's a better word, I would defer to the court. But that was problematic for us. We think that's why plaintiff wanted to keep the trials together. That was their choice. But we had to face that same prejudice. But because the jury is required to adjudicate the issue of damages, the trial judge has a difficult task. He has to allow us to rebut their presentation of damages evidence, and that's all that happened here. And I think Cobage resolves this.
Mr. Soto, both.
Twins
I'm sorry.
were
Go ahead, Judge Rovner.
the twins were removed from their mother's custody due to the actions of their mother. And subsequently, no evidence of abuse or neglect was found. But what relevance did the reason for the removal that one of the twins suffered a broken leg have to the question of damages, given that, I mean, Cruz was seemingly uninvolved with the incident?
The critical portion of the DCF evidence was that the children were removed from Mr. Cruz's custody and Ms. Nunn's custody the exact same month that Mr. Cruz was released from custody, and in particular that the DCFS put requirements on both parents as a result of their investigation to take classes in order to see their children. And Mr. Cruz declined that request from the DCFS, and the mother of his children testified that she wished he had done that. So the DCFS evidence, it needed to come in on the issue of damages so that we could demonstrate that, again, this goes to law society, how Mr. Cruz was going to be present in his daughter's lives.
Mr. Soto, as I understand it, and correct me if I'm wrong, the firms that are representing the respective sides on appeal were the ones that tried the case, right?
Those are the firms, yes.
Were there any, to your knowledge, informal discussions between the attorneys of the different parties with regard to what a bifurcated trial would look like?
Not to my knowledge, Judge. I was not directly involved in the work of the trial of this case. Certainly that's not in the record. I will say that we are frequently surprised at the insistence with which parties opposite us on the V seek joint trials on damages and liability, and we were surprised in this case, as we often are. I was just informed by head trial counsel that issue was never discussed.
All right, thank you.
Yes.
Yeah.
So I know my time is starting to run short here. I know it hasn't been the focus of the court's discussion on the issue.
I do have another factual question, which is really bothering me. I thought that all the parties agreed that the gun belonged to Cruz.
Yes.
But I just heard Miss Olivier say that the gun did not belong to Cruz.
If that representation was made before the court, I apologize. I don't recall it. I don't want to accuse counsel of anything that I didn't hear directly. If that representation was made, it was incorrect. The parties did agree that the gun belonged to Mr. Cruz. That's certainly in the record. I expect counsel will confirm that.
At trial, that was not contested. The gun
at trial, in opening statements, it was fronted by plaintiff's counsel that the gun belonged to Mr. Cruz.
We'll ask Miss Olivier. Yeah.
Absolutely. Yeah. Just briefly on the two other, there's the damages evidence, there's the Miss McRitchie evidence, there's also the issue of the 49 messages. I know that hasn't been the focus of the court's questioning. We think that this was a very careful exercise of discretion from the judge. We think Burton versus City of Zion controls, and controls rather conclusively on the issue of whether it's Rule 404 evidence. It's not Rule 404 evidence. It was offered for a suite of non-propensity purposes. And under Rule 403, the court has to engage in line drawing, kept out the evidence about person of interest in a murder, kept out the video evidence of Mr. Cruz smoking marijuana, allowed in some very limited information about the 49 messages. We would ask that the court find that was an appropriate exercise of discretion. As to Mr. Alexander, we think that the Rule 803-2 invocation on appeal has been waived. There's some dispute in the briefing about forfeiture and waiver. I'll admit there's some inconsistency in the court's usage of the vocabulary in its case law. Puffer versus Allstate calls it a waiver. Plaintiff looks to some language calls forfeiture. That only matters for the court's application of plain error review, which in civil litigation is incredibly rare to be applied, and we don't believe it should be applied here. In any event, with just a few seconds left, we would ask the court find that no discretion was abused at any point in this trial, and that the court affirmed the jury verdict in favor of Officer Eisenhart and City of Peoria. Thank you.
Mr. Sotos, thank you. Ms. LeVay, you have, I will give you, you got a minute left.
To begin, Judge Rover, I would like to make clear that it was stipulated that the gun was Louis and that he did have the gun that was recovered.
So did you misspeak when you said it was not his, or did I mishear?
I'll take it. I misspoke if I said that. I would note, with respect to the video, we can make sure that that gets into your judge's hands, that it was exhibit number 1 at the trial. You cannot hear "stop, show your hands." I would also note that that's the import. Mr. Alexander's testimony, during his excited utterance, he states that he heard the officer say, "Stop, show your hands." With respect to counsel's argument that Kobij is instructive, we would note it is not. In that case, it was a 27-year-old adult testifying to a lifelong adult relationship he had with his mother. What is relevant for a jury to determine is the loss of society at the time of the twins, at the relationship at the time of Mr. Cruz's death. I would also note that this jury was poisoned by hearing this irrelevant propensity evidence, and that's conceded as much in Eisenhart's brief. With respect, at page 33, with respect to the 49 messages, appellee states that the 49 messages was relevant to show that Eisenhart knew he was dealing with a potentially violent person wanted for 2 violent crimes who may well use force. That turned an objective standard into a subjective standard. I do see that my time is up, so thank you very much.
Thanks to you, Mr. Sotos. Thanks to you and your colleagues as well. We'll take the appeal under advisement. Appreciate it very much. Our 4th case of the morning is in appeal number 23-3336, the United States versus Matthew Browndorf. Mr. Roy, nice to see you.
Thank you, Judge.
Whenever you're ready.
All right. Good morning. May it please the court, opposing counsel, Attorney Michael Roy on behalf of appellant defendant Matthew Browndorf. The district court in this case procedurally erred twice while sentencing Mr. Browndorf. I want to start with what I think is the more straightforward of our 2 claims, which is the leadership enhancement. And our claim here is pretty simple. As this court has explained in cases like Tate and Zuno, a participant under 3B1.1 is someone who at least provides knowing aid to a conspiracy or to the crime. The judge is finding here that any of the purported participants may have been acting unwittingly, just does not comport with the legal standard for the leadership.
I take it that you are not contesting the underlying facts that with regard to what the employees under the defendant did. Is that correct?
That's exactly right, Judge Lee. And our view is that Judge Stadmuller definitely could have found that they provided knowing aid. There was enough evidence in the record for him to have made that finding. But there was enough evidence for him to not make that finding too. Lots of things went both ways. There was disputes about how much different employees knew, how much that they were in the dark acting at Mr. Browndorf's behest. And I think the best summation of what I believe Judge Stadmuller's view of the evidence is after the government asked for clarification, and he kind of describes what sounds more like a negligence standard, that they should have known better. If they had looked at what they were actually doing, they would have seen that it was criminal. But that's not criminal liability. That's not something they could have been charged for.
So if our review is de novo, can we take a fresh look at the record and decide for ourselves whether or not the undisputed facts here establish grounds for application of the leadership enhancement?
I would say no, Judge, and that's because that would be an issue of fact-finding. That would be more Judge Stadtmuller's purview. Like I said, the facts could go either way, and there's kind of a large world of discretion here when it comes to the district court.
Do you see any possibility here where if indeed we do send it back, not taking into consideration right now the calculations here, but if we did send it back, that and Judge Stadtmuller had this, this hearing, that Mr. Braundorf could come out worse than he is today? I mean, do you see any possibility of that?
No, Judge Rovner, I do not, and frankly, I wouldn't have raised the argument if I thought that was a possibility. The way I see it is, I don't think that the world of fact finding would be reopened on remand. The government already made its argument twice, both before and after the announcement of what the judge planned to impose. Both times, the district court said, "Well, I'd see it as they could be witting or maybe unwitting." In terms of the inoculating statement, the possibility of the government asking for an upward departure or upward variance based off application note 2, I think there's a lot of problems with the inoculating statement, but the easiest route would be the plea agreement itself, which requires the government to request the bottom of the guidelines, whatever the court decides the bottom of the guidelines is. So if this court holds that the district court misapplied the leadership enhancement, goes back down with a lower guideline range, I don't see how the government could even argue for anything, like even the same sentence now, unless the government breaches the plea agreement.
Well, what if the judge is absolutely horrified by what the judge hears? This happens. I don't know.
Well, I think the judge already expressed that now. So if the Judge Stadtmuller planned to vary upwards based off his view of the facts, I think he already expressed what he saw as the most disturbing, startling parts of it. Not so much the tax crimes, but the embezzlement of the health funds and the retirement funds, which was relevant conduct, not the count of conviction, but relevant conduct. And the government cites some of the striking language Judge Stadtmuller used. I don't think that there is more that's going to shock him now. It's more mathematical, the calculation of the guidelines. And he did sentence Mr. Braundorf within the guidelines. And like I said, the government is held to request a bottom of the guidelines sentence. Just for context, Mr. Braundorf has pleaded guilty to another charge in Maryland, District Court of Maryland. He's going to be sentenced in December. The government has good strategic reasons for, reaching the plea agreement it did here, where it gave up, frankly, a lot. It gave up the vast majority of the counts. I think, 10 counts dismissed? It agreed to a bottom of guidelines, but it's pursuing other charges and other sentences against him at the same time. So this isn't in a vacuum.
The Maryland plea is a federal plea?
That's correct. Yeah.
Is that the only, well, never mind.
That's the only one I'm aware of, Judge Rovner. I don't know if there could be civil cases that I'm not aware of, but I'm aware just of the federal Maryland case.
Yeah.
Mr. Roy, before you get to your into your rebuttal time, can I just ask you briefly? I think you have an uphill climb on your position regarding the loss amount. Set aside the point you just made, which is different, but on the loss amount, what troubles me about that is, this here page of the sentencing memo, which you and your adversary are well aware of, and what Mr. Braundorf represents is that the disagreement is on organizer or leader, but his proposed calculation, starts at base offense level 24. So it's just hard for me to see how he presented that objection to the district court.
Right. Well, and I think there's a distinction between the fact of the loss amount and the effect it has on the guidelines. And, I have to admit, obviously he didn't make the point of if the loss amount was lower, that the base offense level should be lower.
Yeah.
But setting aside the guidelines for a second, just the loss amount is relevant outside the guidelines. It's relevant to the 3553A, multiple 3553A factors, seriousness of the crime, need for just punishment, etc.
So your argument is, even if he didn't preserve it as to guidelines, the
Right.
prior paragraph a few pages earlier may have done it with 3553.
That's exactly right. And then as it goes to the guidelines, our position would be that it's not waived because it could not have been an intentional or strategic decision to lose all the benefit of conceding something while still bickering and arguing about the underlying fact.
Did the defense receive all the background materials underlying the calculation that is referenced in the PSR?
My understanding is no, Judge. However, I was not involved with the trial level. So just based off the record, what my understanding is from the PSR is that the government represented to the parole or probation officer that it had some documents, but the probation officer didn't rely on it. It just relied on the government's assertion. And then the bigger problem is we did, I mean, I think the hardest part is we don't even know how many subsidiaries are at issue. I have no idea. And I don't know if trial counsel knew this or not. I assume Mr. Braundorf knew how many subsidiaries he had, but it's not in the record. And I don't know if it's all employees at all Pluto-Sama subsidiaries.
Yeah, I can't figure out where the 5.4 million came from either. Okay, Mr. Roy, you want to save that time?
Yes, I'll save the minute. Thank you, Judge.
You're quite welcome. Mr. Knight, good morning to you.
Good morning, Your Honor. May it please the court, my name is Kevin Knight. I represent the United States in the district court below, and I represent it today. Judge Scudder, perhaps it makes sense for me to start with your last comment about where the $5 million.
Yeah, I know it's in the PSR. I got that, but what does it represent?
Yes, Your Honor. So I think it's worth noting, and I wish I had made this point more explicit in my brief, it is at two separate points in the PSR. I think it's worth noting it is at paragraph 39, the discussion of the enhancement, but it is also at paragraph 21, which is an undisputed fact adopted by the district court. As I say, I wish I had made that point more explicitly in our brief, but I invite Your Honors to look at that paragraph and then compare paragraph 21 of the PSR to page 7 of the transcript, where the judge adopts those facts. The judge adopted that figure without objection. And Judge Lee, to your question, of course, trial counsel had the discovery that's referenced there. Of course, he had the W-2s and the 941s and the witness statements and the payroll processing data from which that figure was derived. Of course he did.
So is it, I don't want you to speak outside the record, but is it your understanding that the 5.4 million is just a sum total of the withheld but unremitted payroll taxes?
No, Your Honor. It is the combination of the matching portion and the withheld funds from the payroll taxes. That's across the Pluto.
Okay, the employer and the employee side.
Yes,
so
Your
the
Honor.
employer side's obviously not withheld.
Yes,
it's just
Your
the
Honor.
employee side.
And there's no dispute that, of course, that both count as a matter of law for the relevant loss figure. Sophisticated trial counsel for the defendant had the benefit of that discovery, had the benefit of seeing that figure. And just to be clear, he saw that figure at paragraph 21 of the PSR. He saw that figure at paragraph 39 of the PSR. He heard me reference that figure twice during my sentencing commentary. And over and over and over and over again, he acquiesced to that figure. That argument is waived.
I'm still concerned here. When the district court learned that the IRS's losses were so much lower than previously anticipated, didn't he have an obligation to inquire about the accuracy of the $5 million loss that had been calculated by the government? I mean, I looked through the record and I couldn't find any support for a total tax loss.
Your Honor, it's not surprising that we don't see the W-2s and the 941s in the record, because at no point throughout the entirety of this case did the defendant at any time question whether that was the total tax loss associated with this entity. And I think the district court took comfort from sophisticated defense counsel at the trial level making sophisticated objections to those issues for which there were tenable objections. It is not as if the district court was presented with a defense lawyer who was allowing the train to leave the station without saying anything. This defense counsel appreciated that the restitution figures were lower, right? We see him make the point that in the initial bankruptcy proceeding in California, the IRS advanced a restitution figure that was lower, and he makes the point that under 3053A, it would be appropriate to perhaps vary downward based on that figure that was advanced. It's not as if the district judge saw that discrepancy and it went unremarked upon by defense counsel. On the contrary, defense counsel's invocation of it when discussing the 3553A factors suggests that he was aware of the potential discrepancy and was satisfied that it wasn't an issue worth raising. And over and over and over again, when I brought it up and the probation officer brought up that $5.1 million figure, the defendant did not object.
Okay, so, all right, let's say that we do send the case back. Let's just pretend.
Yes, Your Honor.
How much?
I don't want to pretend that way, but I understand that that's not my call. Yes, Your Honor.
But how much does he owe? Just give me a figure so I can sleep tonight.
Your Honor, all told, across the various entities, that's the figure that he owed. Now, part of the reason, I think defense counsel during his sentencing commentary in front of Judge Stadtmiller described the restitution figure as the centerpiece of this plea agreement, and he's right. And that figure represented the considered judgment of the government in consultation with the IRS about what numbers we could made sense for the victims of Mr. Braundorf's conduct in Wisconsin. As Your Honors know, the venue provisions with respect to certain tax offenses are perhaps tighter than they are in other areas of the criminal law. So we're dealing with the Wisconsin-based law firm. And in the context of that firm, those were the figures that we were able to negotiate resolution for Mr. Braundorf, even with a plea just to the payroll tax offenses.
Okay.
But the total tax law, I'm sorry, Your Honor, go ahead.
You were about to do it. Ta-da!
That's the prestige, I think, in Magic, Judge. It's the third act. But it is that figure. It's that 5.1 figure. And I think it's worth noting that to accept anything, to come to a conclusion other than waiver in this case would create some very perverse incentives. We would essentially be inviting defense counsel to stay silent in the face of at least 4 opportunities to object to an important issue. Stay silent, come before this court, and then if my colleague on the other side has his way, not only get a remand based on an unobjected to guideline calculation, but then preclude the government from adducing the evidence that he complains was not adduced despite not making an objection. That simply can't be the law. Certainly, it's not supported by the Montgomery case that defense counsel adduced in a 28-J letter. And even in Montgomery, we see that in a situation like this, where there is at least forfeiture, the government's allowed to supplement the record on remand. And that should at the very least be what this court does. Again, I don't think that that's required here. I think there was waiver over and over and over again when it comes to the total tax loss. But if this court disagrees and finds the issue was merely forfeited, the government should be allowed to supplement the record on remand.
Mr. Knight, can I ask you about the aggravating role adjustment?
Please, Your Honor.
Just to shift over to that. What are we to make of the district court's description of the employees acting wittingly or unwittingly?
Your Honor,
I'll
I
tell you
think
why
that
I'm asking that question. Because an employee that acts unwittingly as to something, it seems very difficult to me that if you stipulate that that person is acting unwittingly, that you could ever convict him of criminal fraud, at least in federal law.
I would agree, Your Honor. And I think that concern is what animated me in the sentencing transcript to clarify what District Judge Stadtmiller meant exactly by that.
Right. I saw that. Absolutely. And then let's set aside the inoculating statement business for a second. But if that's right, what wittingly or unwittingly is literally the kind of the decisive point on whether the aggravating role adjustment could be applied. In other words, if you find that these individuals, the controller, the CFO, et cetera, that they were witting in the fraud, that they knew darn well what Mr. Braundorf was up to, and they were facilitating it in one way or another. Well, the aggravating role adjustment, very well could be sustained, as Mr. Roy is acknowledging. But if your hypothesis is otherwise, or your starting point is otherwise, that it's unwitting, I'm not sure how they meet the definition of participant.
Well, and that's why I think it's so important to focus on Judge Stadtmiller's language at page 37 of the sentencing transcript. When I ask him
to address the leadership enhancement. He gives the inoculating statement, which I'll set to the side.
Right.
But then Judge Stadtmuller says that what he means by wittingly or unwittingly is to draw a distinction between individuals on one hand who are technically criminally responsible but go uncharged, and on the other hand, individuals who are both technically criminally responsible and morally culpable such that charges are appropriate. He's drawing a distinction between culpability and responsibility. You can be criminally responsible but not sufficiently culpable that the government sees fit to charge you with crimes. Mr. Roy, I think, characterized that clarification as something that resembled the negligence standard. That's not what that is. That's Judge Stadtmuller adopting the government's rationale. As your honors look at the PSR addendum, you'll see, and in our brief as well, we discuss how we believed that PF and MS and BR were technically criminally responsible, but they spoke with us under proffer protection, and we ultimately determined that charges weren't merited in their cases, even though they...
What worries me here is I appreciate the way Mr. Roy presented his argument. I think it's something you have to grapple with, and that is, it is very possible, Mr. Knight, that the facts allow a finding of participant status and thus the aggravating role. You could do that here. But what I'm wondering about is where to look in the sentencing transcript that we actually have the finding.
Yes, Your Honor. And if the court will indulge me, it's the very last sentence of page 37 of the sentencing transcript.
I got it in my hand.
And I think perhaps I see that Your Honor has underlined the part where Judge Stadtmuller says that doesn't excuse criminal responsibility. That means that he is finding they are criminally...
I don't know. I mean, if somebody acts unwittingly, I don't know how they could be criminally responsible under federal law.
I agree.
It's not because I don't know of any fraud offense in Title 18, you probably don't either, that imposes strict liability without regard to mental state.
I'm unaware of any, Your Honor. And as I say, that's why I think that clarification is where the court's focus should be. The court, to my mind, should... in the context of the hearing live, I appreciated that what Judge Stadtmuller said in a vacuum was perhaps incorrect and not reflective of what he meant. And that's why I asked him to clarify. And in that clarifying statement at the bottom of page 37, I think, again, I want to just underscore for the court, and I know I'm past my time, but I want to fully answer Your Honor's question. I think it's worth tracking Judge Stadtmuller's explanation that I previously explained of the culpable versus the responsible, and note the symmetry between the government's position in the PSR addendum and the sentencing memorandum we submitted. He is...
go ahead.
I'm sorry, Your Honor, please.
And what is the best quote from the sentencing transcript?
I'm sorry.
That would demonstrate that the district court would have given Browndorf the same sentence had he not applied the leadership enhancement, because all I could see is yes.
And Your Honor, and I agree that is how it starts, but I think we can widen the aperture a little bit when it comes to the inoculating statement. And I think Mr. Roy and I agree on the doctrinal methodology that applies here. When Your Honors consider an inoculating statement like this, we assess whether it is sufficiently detailed and then whether it is sufficiently explicative as to why the enhancement is irrelevant to the court's determination. And if Your Honors want me to stop, I'm happy to. I know I'm past my time, but...
No, go ahead and finish your thought.
Obviously, this clears prong one. We're obviously talking about the sentencing enhancement. It was the only objection that was preserved. And with respect to the second prong of the analysis, we cited these cases in our brief, and I think they're relevant here. Carraway, Asbury, beginning on, I believe it's page 29 of our brief. Those cases note that the explanation doesn't need to be necessarily lengthy. Carraway says that you need not belabor the obvious. And what would Judge Stadtmuller say? Would he say for the third time that he was driven to tears by these victims? Would he say yet again that Mr. Browndorf knew better? Would he say yet again that he found the impact on these victims to be devastating? When you read the sentencing transcript, Judge Stadtmuller said the harm to these victims jumps off the page. And then he described at two separate occasions how he was driven to tears by the victim statements. I think under Carraway, under Asbury, Judge Stadtmuller wasn't required to explain for a third time that he was driven to tears by this case. He wasn't required to explain yet again that when he weighed the 3553A factors, he found 48 months to be the appropriate sentence. I think Mr. Roy suggests that the fact that the government's the government's recommendation was tied to the bottom of the guidelines cuts in favor of his position. It's exactly the opposite. The fact that Judge Stantler jumped the government's position is just one more arrow in our quiver when we say Judge Stantler weighed these factors, he dove into this record, he considered the victim's statements, and then when he was asked by me whether he would have given the same sentence, he gave a considered answer. Subject to Your Honor's questions.
Okay.
Yeah, please.
So assume for a moment that we think that we can't glean as much from the transcript as you do. Okay?
Yes, Your Honor.
So then the question becomes, do we need to send it back, or can we look at the facts since they're undisputed and make our own determination whether, as a matter of law, that satisfies the requirements of the leadership enhancement?
I think Your Honor is exactly right. If I take your question to mean that, of course, this court has long-standing precedent that suggests that there's an independent basis in the record that's undisputed, that supports the imposition of the enhancement, the court is free to do that. And I would encourage the court to do that here. And I would encourage the court, if it is inclined to, as you say, Your Honor, if you read the transcript more narrowly than I do, and if the court is inclined to analyze the case in that way, I would encourage the court to not just look at the PSR. It's clear from pages 3 and 7 of the transcript that Judge Stantler was adopting both the PSR and the addendum, and the addendum includes various memorandums of interviews with, I believe it is MS and BR who are in the addendum. So not only do I think the answer to your question is yes, Your Honor, your purview it's fully consistent with this court's precedent to take countenance of that evidence that's undisputed and impose the enhancement if you believe it applies. But I would just, as I say, Judge, I would encourage you to not limit yourself to the PSR and to similarly incorporate the undisputed elements of the PSR addendum in the record. Subject to Your Honor's questions.
Mr. Knight, thank you very much. We appreciate it. Mr. Roy?
Thank you, Judge. I want to start very briefly with inoculating statement standard. I don't have the quote in front of me, but I believe this all started with Asbury, where there was just a sentence, detailed statement that explains the parallel result. That has solely morphed into this sort of like doctrinal two-prong test, which we both discussed in our briefs. But I don't want to miss the forest for the trees here, which is that this is ultimately just standard harmless error analysis. The question is, would the result be the same on remand, or would the result have been the same without the error? And it's not just, parsing the judge's language, whether the statement met the two prongs. I think we have to look at everything. And that includes the plea agreement. That includes earlier when the judge was talking about how his view of the sentencing guidelines impact and are always the starting point for him. It's not just whether the word, we disagree on what's involved in the inoculating statement, but whether the word yes was enough or not. I also want to talk briefly back about the tax loss claim. I want to be clear that in Mr. Braundorf's sentencing memorandum, he didn't just say, I want a departure based off what it would have been if the tax loss was lower. It's at page 9 of his sentencing memo. I admit he could have flagged it better. He could have done more to put it, but he does refer to it as these amounts. He contrasts the amount that the government gives against the amounts from the bankruptcy proceeding, the restitution. He calls the alternative loss amounts more realistic than the government's number. That's language of a factual dispute. And in terms of the question of whether this is going to create bad precedent for preservations, now setting aside the guideline parts, just the fact of the loss amount and the Rule 32, whether the judge settled the dispute or not, this is not the type of claim that's really ever going to come up unless someone makes an objection. If Mr. Braundorf had said nothing at all, we wouldn't have been able to challenge the tax loss because even conclusory statements in the PSR may be adopted without objection. Unless there's further questions.
Okay, Mr. Roy, thank you very much.
Thank you,
Mr. Knight, thanks to you. We appreciate the advocacy on both sides. We'll proceed to our fifth argument of the morning. It's in appeal number 233420, Timothy Hofstede versus the Northeast Illinois Regional Commuter Railroad Corporation, or METRA.
Morning. May
Morning.
it please the court, counsel. Taylor Muzzy on behalf of plaintiff appellant Timothy Hofstede. This matter is before the court following the district court's decision granting summary judgment in favor of Metra. The district court held that Hofstad presented sufficient evidence to meet the first two elements of his claim under the ADA. First, that he's disabled as a result of his ADD and his migraines, and second, that he's qualified to perform the essential functions of his job as a police officer / canine handler. So, like many employment discrimination cases, we are here on the element of causation. Hofstad presented ample evidence from which a jury could conclude that Metra took multiple adverse actions against him because of his disabilities. Hofstad asked this court to reverse the district court's grant of summary judgment for Metra and remand this matter for trial.
Mr. Mussey, the parties seem to agree that the dispute started when Hofstad failed to reply to the MRO's three requests for proof of valid prescriptions. The parties also seem to agree that when a Metra employee fails a drug and alcohol test, the policies that Metra applied to Mr. Hofstad are the correct policies to apply. If Metra was simply enforcing the pre-written policy, excuse me, against Mr. Hofstad, doesn't that mean that Mr. Hofstad cannot prove that Metra's actions were discriminatory?
Judge, I agree with you that the initially positive drug test was the kind of the source of the dispute in this matter from which everything flowed. Metra argued to the district court and would have this court believe that that was unavoidable or unalterable course of action, right? From the moment of that initially positive drug test, nothing else could happen except the path that Metra went down. And Hofstad submits that that is not the case. First of all, because Mr. Hofstad had, everything was above board. He had reported these prescription medications to Metra on Metra's required form. Both his Adderall and his Norco were on record with Metra as things that he were taking and things that he was permitted to take. Now, unfortunately, he did not respond to the MRO's phone call to validate those prescriptions following the initially positive test. Had that happened, we probably wouldn't be here today. However, sorry, Judge, he did provide those prescription medications within 5 days. So 5 days later, he provided those prescriptions to the MRO and to Metra and had that test result reversed from a positive to a negative.
So am I wrong if I thought it took him 15 days to send the copies of the labels from his prescription bottles to the MRO and Metra?
So, Judge, the random test he submitted to was on July 24th, 2018. The test was deemed positive on August 3rd, 2018. And Mr. Hofstad provided those prescriptions and the test was reversed on August 8th, 2018.
So it depends where we count from, right?
That's one way to look at it, yes.
Yeah, okay.
But, you know, this was, to be perhaps too flip about it, we're not launching the space shuttle here, right? This was not something that then took off and couldn't be diverted at some point. Metra could have, once those tests were reversed from a positive to a negative, pulled him out of the program. They put him into the rehabilitation program as if he was a substance abuse offender, which he was not. And they could have, once he provided those prescription medications, they could have pulled him out of the program and said, you clearly don't belong here. This was a mistake, right? This was a mistake that you weren't able to respond in time. We had the documentation on the record ahead of time. We understand what happened here. But they did not do that. And instead, they are hiding behind that initially positive test to justify the course of action that followed.
See, I read the record a little bit differently. And you can tell me I'm mistaken here. Chief, and I don't know his first name, Chief Perez, Perez, thought that your client was, the jargon that you all are using is not certified by this training board, training and standards board, and he was not recertified or relicensed or reauthorized, whatever the right words are, until September 17th. But the decision was already made as to the replacement of the handler, was it not, on September 13th? And so if the decision maker, I see his name here, Joseph, is Joseph Perez, and Joseph Perez made the decision on the basis that Mr. Hofstede was not licensed or certified to be a dog handler for Metra, how can that reflect discrimination on the basis of disability?
Because
Now, it may be that he's mistaken, right? But the plaintiff, there's no showing that that's like a lie or pretext or anything like that.
Well, we would submit, Your Honor, that his email from September 19th, 2018,
Right.
From Chief Perez, first, it falsely claims that Mr. Hofstede was decertified on September 17th and said he was reinstated on September 17th. That is incorrect.
Okay, what evidence shows that Mr. Perez or Sergeant Perez knew that that was incorrect?
There is none, but I think it needs to be paired with the rest of that email, where he questions Officer Hofstede's ability to comprehend written text, which he also says in his email, these were issues that the Metro Police Department raised with the Employee Assistance Program.
Right, but isn't the context of the second paragraph around Metra's trying to figure out if they can place him in some other position? In other words, the decision to not put him in the handler, canine handler role was made on the 13th. But I thought on the 17th, or I'm sorry, by the 19th, there was still a question, can he perform another role?
I think that his email on the 19th reflect his held perceptions about Mr. Hofstede and the prescriptions he was taking as it applied to the application process, because Mr. Hofstede did apply for the canine handler position on September 13th, before that closed and his replacement was selected on September 14th.
Okay.
Those statements in his email demonstrate his animus towards Mr. Hofstede and his prescription. And to the point that Metro's Police Department raised this with the Employee Assistance Program, who told the police department that those concerns were unfounded. And then he further indicated that he had questions or concerns about impairment from Mr. Hofstede's prescriptions. So I see I'm running short of my time here.
You want to save your rebuttal time? It's up to you.
If I may just wrap up a little bit now to note that there are, in addition to the things I've just talked about, there are issues of suspicious timing. There's issues of animus in terms of the commander who pulled Mr. Hofstede out of service. The things he said to him at the time he pulled out of service, saying, you had a piss test a couple of weeks ago and it was fucking dirty. I mean, these are the kinds of comments that demonstrate the animus towards Mr. Hofstede and the disabilities he had and the prescriptions that he took for those disabilities. And I will reserve the rest of my time. Thank you very much.
Okay, you're quite welcome. Mr. Moore, good afternoon. We'll hear from you.
May it please the court. My name is David Moore. I represent the appellee Metra. The district court's decision granting summary judgment in favor of Metra should be affirmed. The record establishes that it was plaintiff's own repeated inaction that caused the entire chain of events about which he complained.
Mr. Moore, Mr. Hofstede talks about the fact that he self-disclosed his medications. And I know defendant Metra's position is, well, that's not a acceptable or sufficient response to a positive drug test, that they need copies of prescriptions. Is that in a handbook or a guidebook somewhere so that Mr. Hofstede and other employees would know that?
Yes, Your Honor. That is, and this is undisputed, that is contained in Metra's drug and alcohol policy. And if you look at our party's joint statement of undisputed facts, which were submitted to Judge Ellis, The parties agreed that the self-disclosure form plays no role in the medical review officer's analysis of a drug test result under the policy, and that the forms are, quote, an employee's self-report of medications and not medical evidence of a valid prescription by a doctor. And it was also undisputed that employees, regardless of an approved medication, must provide a legitimate medical explanation to the MRO in the event of a positive drug test. So that's all in the drug and alcohol policy, which Mr. Hofstad agreed that he had received.
So a notion that Mr. Halstead just thought he had clicked all the boxes because he had pre-disclosed, that would be inconsistent with what's in the handbook, had he read the handbook, and presumably he did.
Exactly. And again, going back to the undisputed facts, it's undisputed that plaintiff, a sworn police officer, testified positive for amphetamine, hydrocodone, and hydromorphone. It is undisputed that after plaintiff's drug tests were non-negative, the medical review officer attempted to contact plaintiff 3 times. It's undisputed that the MRO did so to obtain a legitimate explanation consistent with the policy before reporting a positive test to Metra. And only after plaintiff did not respond to the medical review officer's 3 calls did the MRO then report the drug test to Metra. And I believe I heard counsel just say, had plaintiff responded, had that happened, we would not be here today.
I do want to ask you something about that rehab program. His drug test, of course, was the only reason that he had to go through Metra's rehabilitation and education program. Now, that drug test was revised from positive to negative on August the 8th. And Hofstad did not begin the program until August 18, 10 days later. Given that his drug test result was changed long before he started the program, why did he have to complete this rehabilitation and education program at all? I mean, what's he doing there?
So there's 2 things going on here, Judge Rovner. First, Chief Perez honestly believed that the plaintiff was decertified by the Illinois Law Enforcement Training Standards Board at that time and ineligible for employment. The other piece of this is that when plaintiff was notified of his positive drug test, he was given a choice. The choice was to participate in a hearing about a week later, an investigatory hearing pursuant to the collective bargaining agreement to challenge that drug test, or to waive his right under the collective bargaining agreement to participate in the hearing and elect to participate in the R&E program. So this was all laid out in writing to him and explained to him. So he had the choice. Do I want to challenge the positive drug test and go to the investigatory hearing, or do I want to take the certainty of waiving the rights of the hearing and electing to participate in the R&E program? So he had agreed, pursuant to the rules in the collective bargaining agreement, to waive his hearing and to complete all the requirements of that process, which included going to the EAP.
Can you explain that again? I'm not following that. If the test was revised, is Judge Rovner meaning you're clean, you're clear, you've submitted the objective prescription evidence that way. The positive result is now reversed, however you want to describe that. Why wouldn't someone in his position say, well, I'm not going to a drug rehab class. What would I go to a drug rehab class for? I was taking prescription medication.
I don't know why he elected to pursue the path that he chose to pursue.
But when you were responding to Judge Rovner, you responded with points about Chief Perez, and what I was thinking is, what does Chief Perez have to do with why the guy would go to a drug class or not?
So, at the moment in time that he elects to participate in the program.
Right.
He had the choice. Do I want to contest the drug test and say, no, this is wrong, I have prescriptions, or do I want to agree to the collectively bargained provisions?
Yeah,
that
this
I'm
is where maybe we're just ships passing in the night. At the time he made that decision, though, Judge Rovner just established that the test had been reversed.
Let me step a minute back then. So he signed the forms on August 3rd, before the drug test had been reversed. So on August 3rd, he's notified of the drug test by Commander Wendell. Several hours go by, and he speaks to Commander Mack at night, and Commander Mack tells him that Commander Mack can't make the decision for him. Commander Mack says he has to make his own choice, and he should talk to his own union lawyer. And the hearing wasn't for another week, yet he went ahead and
So the
chose...
choice was not made after August 8th. It was
Correct.
made before August 8th.
Correct.
Okay.
My
When was-
apologies for the confusion.
When was he informed that his drug test results were reversed?
I don't know if that is crystal clear in the record. He was informed that he was able to apply for reemployment under the collective bargaining agreement on September 17th, but I don't know if it's clear when he exactly learned that the test had been reversed.
But it was revised on August the 8th. Surely somebody must have said, you know, don't worry about it, kiddo. You're fine. I am so flummoxed by this. 10 days later, he's in this program. I mean, is your program filled with people who shouldn't be there? I mean,
So again, Your Honor, he chose to go into the program. And at that time, once
you gave him this Hobson's choice.
Well, I don't know if it was a Hobson's choice. He had the choice to contest his the finding of a positive test at the hearing, or the choice of pursuing the rehab program. He had a choice. He didn't have to decide that day. He did, after being told to talk to a union lawyer. And he wouldn't have been reinstated because Metra immediately reported his dismissal and positive drug test to the Illinois Law Enforcement Training Standards Board. They understood, albeit incorrectly, that meant he was not even eligible for employment. He couldn't even go back into the job until the board had recertified him. So the whole question is, was plaintiff's disability the catalyst which prompted Metra to take any of these adverse actions? Or was it the undisputed fact that he didn't respond to the MRO's 3 calls? If he had responded to the 3 calls, we wouldn't be here today.
Do you know why it took? So, Dr. Feldman contacts Ms. Lang on August 8th, tells her, we got copies of these prescriptions. And then it took Ms. Lang until September 7th, so almost a month later, when Ms. Lang tells Perez and Riggio that Halstead is clear to return to service. Why did it take that long?
So in the drug and alcohol policy, you also have to complete a medical exam and another drug test. He went for the medical exam and the drug test on August 27th. That's in Undisputed Facts 83 and 84.
But by then, Ms. Lang, who was in charge of this office, knew that he had prescriptions that resulted in the false test, right?
Yes, that's true. But at this time, they're honoring the rules set forth in the collective bargaining agreement. And then in terms of why it took until September 7th, that was because at the final medical exam on the 27th, that doctor sent questions to Hofstede's doctor that were not answered until September 7th. So as soon as they got the final clearance from the outside doctor at Concentra, that is when the medical department told the police department that he had completed the program.
So everything is governed by the collective bargaining agreement with regard to these timelines and what need to be done, and no one wanted to veer from it seems like.
Correct. And no one from the union asked, neither the plaintiff nor the union asked the department to make any changes to those bargain for rights and procedures. I see that my time is up. If you have any other further questions, I'd be happy to answer them.
Okay, hearing none. Mr. Moore, thank you very much.
Yes.
Appreciate it.
Thank you, Your Honors.
Okay, Mr. Muzzy, you've got about a minute and a half.
Thank you. I'd like to pick up on Judge Rovner's comment that Hofstede was faced with a Hobson's choice. When he was at that meeting with Commander Windle when he was first removed from service, there really are disputed facts about what he believed his choice was. In addition to swearing in his face, as I mentioned at the end of my opening remarks, Commander Windle also told Officer Hofstede that his union couldn't help him and that he didn't need to talk to his union. He also told him that if he enrolled in the program, he would not lose his job, which is in fact untrue, because what happens when you go into the rehabilitation program is you technically become a dismissed employee who is then subject to reinstatement after you complete the terms of the program.
Mr. Muzzy, what's the record show, if anything, on your view of when he started the program, correct, on the 18th of August?
I believe that's correct, yes.
Okay. Does the record tell us when he began the program, was he aware or unaware that the test had been revised?
I believe he was aware on August 8th, Your Honor, when the day that he contacted the MRO. 'Cause
Okay.
I believe the test result were...
And what's the best explanation from the record about why he didn't say, what in the world am I doing at a drug program?
I believe he did. He raised it with the substance abuse professional who said, you shouldn't be here. This is a paperwork problem. This is a clerical problem. And then it got to Metro, and Metro said, no, he has to go through the program. Again, it was...
So all this is in the record? We'll see all of this in the record?
Yes, Judge.
And what's the best evidence of somebody telling him, notwithstanding the revised test, you must complete the program?
Well, there is his testimony about his conversation with the substance abuse professional, Mr. Hofstede. And I believe, I don't know off the top of my head, Your Honor.
Okay, very well.
Thank you.
Mr. Muzzy, thanks to you. Again, Mr. Moore, thanks to you and your colleague. We'll take the appeal under advisement. That brings us to our sixth and final argument of the morning. It's in appeal number 24-1042, Jim Rose and others versus Mercedes-Benz USA. Mr. Wright, good morning. Good afternoon.
Good afternoon, Your Honor, and may it please the court. I'm David Wright, and I represent plaintiff appellants Jim Rose and Anita Gian. Your Honor, the sole issue before this court is what quantum of evidence of mutual assent will satisfy a moving party who is attempting to enforce an arbitration agreement to establish that an agreement of arbitration actually exists. The district court's answer in this case is almost none at all. And this is governed in this case, appellant Jim Rose is a Illinois citizen. His would be governed by Illinois law, which is what the court referenced, district court referenced in its ruling. Anita Gian is a resident of New York, and while the court did not conduct an independent analysis under New York contract formation law, it presumably would be the same. Under Illinois law, the existence of a contract, its terms, and the parties' intents are questions of fact to be determined by the trier of fact. Whether parties have mutually assented to the terms of the contract is a question of fact to be determined by an objective standard. In this case, the court ruled that Mercedes-Benz had made a prima facie showing that there was mutual assent to the terms of service agreement related to the Embrace subscription service, and that the plaintiffs had failed to rebut that. This was...
Now, the plaintiffs claim they do not recall receiving the terms of service. They're not claiming that they never received the terms of service, right?
The plaintiffs in their declaration both state that they do not recall having ever clicked on the I accept button referenced in one of the two ways the subscription service can be subscribed to, and they did not recall ever receiving the terms of service agreement. Mind you, these declarations were 6 and 5 years after the events took place. The district court emphasized that fact in finding that the plaintiffs had failed to rebut the showing by Mercedes-Benz as to mutual assent. But that's not dispositive here, because the court did rule, as a matter of law, based on what it viewed as undisputed fact, that mutual assent had been established. And in so doing, a decision which this court reviews de novo, that court erred. That court committed error, because even if what would be happening is if the court required the plaintiffs in this case to say affirmatively, I never received the terms of service agreement. If that were the inquiry, that improperly shifts the burden to the plaintiffs. The law is clear. Mercedes-Benz has the burden of establishing mutual assent to the contract that includes the arbitration provision. So here we have to look at the declaration that Mercedes-Benz offered.
I don't know if it really shifts the burden of proof. It shifts the burden of production, right? I mean, this happens in summary judgment all the time, where the moving party puts, where a defendant moves for summary judgment and they produced or point to an undisputed facts, and then it's the non-moving party's burden to come and point to something that would dispute that. And so here, Mercedes-Benz said, with the declaration of Thomas Krixey, I think.
Mr. Krix.
Krix, thank you. That, this is what the practice was at the time. And so if they subscribed, then they would have gotten this, they've had to do this. And the plaintiffs come and say, we don't know whether or not we did that. How does that create a dispute of fact?
If Mr. Grix had said with any detail what the practice was at the time, this perhaps comes to a different result. We have to go back to that declaration, because there were some serious errors made based on that declaration, the most notable of which was both the district court at page 8 of its ruling and the appellee in its brief to this court both state that Mr. Grix states on numerous occasions plaintiffs were provided with the terms of service agreement. That was included in both the order and appellee's position. But let's look at the declaration, which is at appendix page A1, paragraphs 4 and 5. Mr. Grix, who, by the way, was an engineer in the connected car department from 2020 to 2023, he never says, he references paragraphs 4 and 5 in the present tense. He doesn't refer to what was the practice in 2015 or 2017 when plaintiffs purchased their vehicles. But he says there's two ways you can subscribe. One is at the dealership. The consumer may be presented with an iPad or a computer where they have to click an I accept button. The second way is they can call a call center. Now, we don't know this call center, presumably operated by Verizon Telematics Inc., who's the contracting party for the Embrace service agreement, that they can call the call center. So let's talk about the first way. There is no information provided by Mr. Grix what appears on the page that includes the I accept button, other than there's an I accept button. We don't have a screenshot to show what it shows. We don't have him describing what text appears on the I accept button to lead the consumer to understand what they're accepting. He does not say that the terms of service are included in an inset box that the person can scroll through, which would be the case with the click wrap agreement. He does not say.
Was he asked those questions? Was there any follow-up?
There was no hearing on this, Your Honor. There was a motion for a motion to compel arbitration. His declaration was provided. The parties opposed on the papers, and the court issued its ruling without a hearing. There was no trial. There was no evidentiary hearing.
So the plaintiff did not request any discovery with regard to Mr. Grick's motion?
Plaintiffs did not
Declaration.
request any discovery with regard to it. However, plaintiffs, given the paucity of Mr. Grick's declaration, should not have been required to conduct discovery. It is Mercedes-Benz burden to establish that there was mutual assent. So with the click button, there's simply no information in the record about what's referenced there. With regard,
Okay, I understand, your argument that Mercedes did not provide specific evidence that it gave plaintiffs notice of the terms of service. But in your view, absent some sort of admission from plaintiffs that they received notice to the terms of service, what evidence could Mercedes provide that would sufficiently demonstrate that Rose and Gian received notice?
so again, by looking at the numerous cases that both at the district court and appellate court levels that have dealt with this, there are a number of things they could have said that they did not. First of all, with regard to, and I need to finish this thought, with regard to the call center, there's no information about what the call center would have, an operator at the call center would have provided the plaintiffs with regard to the information about the terms of service agreement. What he says in his declaration is, individuals who enroll via the Embrace call center are informed about the TOS agreement verbally during the call and are told where they can locate and review the TOS agreement. He does not say what they're told about it. He does not say what specifics are provided. He does not say whether they're informed that there is an mandatory arbitration provision. He does not say where the TOS agreement was located that they could go see it, whether that's because he doesn't know or whether that's because they failed to set forth here. There's no call script. There's no training materials. Presumably, call centers would have that type of material. That should have been produced if they had it. Then he goes on to say, after the subscription is entered into by the plaintiffs, they would receive a welcome kit, 1, and a welcome email, 2. As to the welcome kit, what he says, and this is paragraph 7, following activation of Embrace, subscribers receive various documents, including a welcome kit that once again informs them the service is subject to a TOS agreement. He does not say the TOS agreement is included with the welcome kit. They do not provide a copy of the welcome kit or an exemplar of the welcome kit. And with regard to the welcome email, this is the closest they get. They say there's a link to the TOS agreement in the welcome email. But they don't provide the welcome email, so this court can conduct its fact-intensive analysis to determine whether that would put this consumer on notice or an objectively put the consumer on notice of the terms to which they're giving assent. So it's that failure that dooms the motion. And I would just direct the district courts have dealt with almost identical scenarios, both in Melvin v. Big Arts Data and in Gilbert v. IC Systems, where almost identically vague declarations were provided in support of a motion to compel arbitration. And the district courts in those cases said it is impossible for the court to conduct the fact-intensive legal inquiry it must make in order to determine whether a contract was formed that includes the arbitration provisions in those cases.
Okay, Mr. Wright, let's do this. Let's hear from. I'll give you a couple minutes on rebuttal. Okay, let's hear from your adversary, and we'll pick it up from there.
Thank you, Your Honor.
You're welcome.
Good afternoon, Your Honors. Good afternoon, counsel. May it please the court. I'd like to start, if I could, with the last thing that opposing counsel was discussing, which is these cases, Melvin and similar district court cases. And this sort of theme runs through the brief of the appellants, where they're trying to analogize this case to these sort of I'll call them the hybrid browse wrap cases, in which there's a transaction that takes place completely online. I think that whole structure is wrong. those cases are about constructive, not actual notice, and I'll get to why that's relevant here. And they're also about transactions that took place solely over the internet with sort of a single transaction, where there was some legitimate question about, and this is a quote from Seguros, whether the plaintiffs would realize they were agreeing to a contract at all. Neither of those things is true in this case. First, here, the district court found that plaintiffs had actual notice of the terms of service. That's a factual finding, which even the plaintiff's brief acknowledges is actually reviewed for clear error in this context. That's from the Cass case. And the plaintiffs offer no evidence whatsoever rebutting that. And Mercedes actually showed that plaintiffs agreed to the TOS at the time of their initial enrollment, and that they were subsequently repeatedly informed of the terms of service, both in the welcome kit and the welcome email that opposing counsel mentioned, but also in subsequent communications before they signed up for and then paid monthly for the service. So that gets to the second point, which this is not the sort of internet-only browse wrap transaction that we see in cases like Melvin, where there's this sort of detailed analysis of the font and the layout.
Yeah, Mr. Wilkerson, can I ask you a question that throws me off about this case?
Yes.
Okay. So you and your adversary and the district court, to my eye, and it may be correct, I just need it explained to me.
Yep.
Everyone is focused on whether there is assent of basically at the time that Mr. Rose and Miss Guillen bought the vehicles and activated the Embrace service. That's what everybody's focused on. That's what the argument we just heard from Mr. Wright is about. That's what your argument is about. That's the way the district court proceeded.
Well, I agree that there was a significant focus on that. I would say that we emphasized and continue to emphasize here before this court that even if there were not assent at that time, that there was assent at later times, including the renewal.
Okay, so that's what I want to focus on, because with a subscription-based product,
yes, Your Honor,
where a subscription has a beginning point and an end point, and let's just focus. I'm pretty sure it's true with respect to Mr. Rose, and it's definitely true as to Miss Guillen. Okay, she received a complimentary subscription for 7 months.
Yes, Your Honor.
And that complimentary subscription began in or about January of 2015.
That's
I'm looking
correct.
right at paragraph 17.
Yes, Your Honor. If you don't mind, I'm going to
Yeah, go ahead. Go ahead. Okay, and then we know that she paid monthly subscriptions thereafter.
That's correct.
And then she stopped in November of 2022. Okay.
That's correct.
So when we look in turn to the underlying class action complaint
Yes, Your Honor.
that Mr. Wright's clients filed, okay? The claims in that underlying complaint, as I've sorted them out, or best you can help me here, they seem to sort into kind of two buckets, if you will. One bucket are the warranty claims arising from Mercedes' alleged failure to replace the system when it became obsolete, when G3 was no longer there. Okay, and the second category of cases are like false advertising, fraud, unjust enrichment, all of that. Okay, now if that's right, the first category of claims would have only arisen at the time of the renewal for somebody like Miss Guillen. It's the only thing that would make any sense.
Yes, Your Honor.
Okay, if that's right.
Although I'm not sure it matters for purposes. It's undisputed that these.
Well,
claims
here's why I'm
fall within
getting
the-
at this. We know, at least as I read it, the U.S. Supreme Court on 2 different occasions, in Dean Witter, and then in 2011 in KPMG, said arbitration is not all or nothing. What they very clearly said there is you have to examine the underlying complaint and determine which claims are subject to arbitration. Some may be, some may not be. For those that are, they go to arbitration. For those that aren't, they don't go, even if that results in very inefficient litigation. Okay, they did that per curiam. And so what I'm wondering about here is when you look at the Guillen situation, I think it's there for Rose too. What do we know about assent at the time of renewal from the declaration?
Well, we know that the terms of service provided that continued use of the service would constitute assent. And just to be clear, although the other side argues in their brief that they contest assent, if you go read their briefs, they're really just arguing notice. They don't contest that if it's the case that you're on notice of the terms of service, that your continued use of that service would constitute assent. And
okay,
so,
here's all we know to my eye. You can tell me I'm wrong. You know this declaration better than I do.
yes.
All right, paragraph 7. The TOS agreement is also referenced or otherwise linked to subsequent communications with subscribers, including renewal reminders. That's all we know about it.
Well, if they knew about the terms of service that governed it, then we know what those terms say about accepting the terms, and that's at A18, the terms of service effective May 17th, 2016.
But I don't know, what I don't know is, did the renewals occur? These are questions I have. I don't think the declaration answers it. Did the renewals occur by email? That seems to be the U.S. mail. I don't know.
Well, I don't understand, Your Honor, why it matters.
It matters because of what the U.S. Supreme Court has held in Dean Witter and in KPMG. That's why it matters.
I don't think so, because if there was notice of these terms at the time of the renewals, then the renewal, however accomplished, whether via email...
Where can you tell us that there was notice of the terms at the time of the renewal based upon the record before us?
There was notice of the terms at the time of the sign-up.
Obviously,
the time of the renewal is subsequent.
Are you going to pay attention to my question?
Yes, I'm listening, Your Honor. Yes.
My question is based upon this declaration. That's what I want you to focus on. That's what I'm asking you about.
Yeah, Your Honor, I understand the question.
What is
maybe
your
I don't
client?
understand the premise.
Will you listen to my question?
Yes, Your Honor.
The premise is based upon the United States Supreme Court's decisions in Dean Witter and KPMG that assent is not an all or nothing matter. And so the premise is in a subscription related context, which is the context before us here. How do we figure out assent? And my question is, you have Ms. Guillen saying, I renewed a bunch of different times. And so the premise is whether that renewal included assent. That's my question.
Right, and I suppose what I'm trying to respond is that if you're saying, and I think you are, that the declaration provides evidence that there was notice of the terms at the time of the evidence.
It's a question. That's my question. How should, against the backdrop of that question, how should we analyze this?
Well, I believe that Your Honor should find, as you said, that the district court focused on whether there was assent at the time of the initial sign-up, and that was not an erroneous finding, that was based on unrebutted evidence in the record, and that from there, there's no need for a separate showing of assent each time that the...
now you're getting to it. Why? In a subscription-related matter.
Well, because if you are subscribing to a service and you're aware of the terms of the terms that apply to that subscription, then when you choose to continue to renew that service, that is an objective manifestation of your continued assent to those terms, and that's all that's required. Assent is a manifestation, an objective manifestation of content that you have reason to know.
So your position is that as a legal matter, if we look at what Ms. Guillen has said, or I'm sorry, how do you say it? Gritz?
Gritz.
Yeah. When you look at the Gritz declaration in paragraph 19, that she was renewing every 6 months. Is it your position as a legal matter that we need not concern ourselves with whether those renewals contained assent?
My well, I have two positions. One is that it's not actually contested that they contained assent. That if you read the appellant's brief, this case is really entirely about notice. And secondly, that evidence is sufficient to find an objective manifestation of assent. Because if we accept...
And what's the underlying evidence?
That the fact of renewal is objective manifestation of assent if you had notice and assented to those terms in the first instance.
So if the two of them had said, or the whole class, whatever, had said, nah, we don't want to renew, then what?
Well, had they not renewed the service, then at least as to claims arising thereafter, they may have an argument that they were not subject to the. I'm not sure whether they'd have that argument, whether that would be a successful argument or not, but it would be at least an arguable point.
Mr. Wilkinson, did the plaintiffs or the putative class members receive renewal reminders as the time came to renew their subscriptions?
Yeah, Your Honor, I believe Mr. Grix's declaration notes that there were the terms of service were referenced or otherwise linked to in subsequent communication with subscribers, including renewal reminders.
So if I had a 6-month plan, and presumably in the 5th month I would get an email from Mercedes-Benz saying, "Oh, it's time for you to renew, and by the way, these are the terms of service."
Yes, Your Honor.
Okay.
Yeah, so the legal question is whether we should focus at all on renewal assent.
Yeah, and Your Honor, I guess my answer would be that even if you do, that all that is required is an objective manifestation of assent, and that the law is quite clear that the use of a service, the ongoing use of a service, does objectively manifest assent, and that while there are headings in the plaintiff's briefing about assent, if you go read those arguments, there is no argument that you may objectively manifest assent by continued use of the service. The only argument is as to notice, and here the district court found actual notice that was based on unrebutted evidence in the record. And just one more point, because I know my time is well expired, is that the other side said, well, that would effectuate a burden shift if we had to come forth with affirmative evidence. That is exactly what this court said in Tender. Once the advocate for arbitration comes forward with evidence sufficient to show that there was an arbitration agreement, then the other side must come forward with specific evidence. It can't just have general denials. This court in Cass called out specifically the fact that a failure to remember, a failure of recall was insufficient. That's also, I believe, in the Boomer case. So these are well-established legal principles.
Okay, Mr. Wilkerson, thank you.
May I quickly ask?
Please.
Thank you. So I take it that your bottom line position is this, that the shortcoming is that neither Rose nor Gian stated anywhere that they did not agree to the terms of service. They only say they do not recall seeing the terms of service, and they have not addressed the repeated resubscriptions after the initial subscription, at which point they would have been reminded about the terms of service. Is that it? Is that your position?
Yes, Your Honor, it is, and I would just call out that those repeated resubscriptions have another important legal consequence, which is that they sharply distinguish this case from the cases on which they rely, in which there's a singular transaction. This was an ongoing subscription service which these plaintiffs allege in their complaint they knew about and cared about before they ever walked into the dealer. The idea that they didn't know there was terms of service here is it was correct for the court to find there was no material issue of fact about that. Thank you, Your Honors. And,
Mr. Wilkerson, thank you. Okay, Mr. Wright, why don't we give you 3 minutes? You might want to address this renewal point. Is renewal in the case, or is it not in the case, and how should we think about it?
So, Your Honor, respectfully, I think the court should think about the renewal, apply the same analysis, should be a rigorous analysis that applies to the initial sign-up. Was the consumer put on notice of the terms of service agreement? I didn't finish my thought from my prior argument. I just want to do that, because if you look at, and it all comes down to the Griggs Declaration, if you look at paragraphs 4, 5, and 7, where it talks about the initial sign-up, the welcome kit, the emails, and the renewal reminders, nowhere in those 4 paragraphs, or I'm sorry, in those 3 paragraphs, does it ever say the consumers were provided with the terms of service agreement. Even with respect to the renewal reminders, not only does it not say how those reminders were delivered, was it email, was it US mail, was it some other means, nor does it say when, 6 months before, 6 days before, gives no information. It says in the alternative, the TOS agreement is also referenced or otherwise linked in such communications, leaving the court to guess, is it referenced or is there a hyperlink? If there's a hyperlink, does that hyperlink appear in sufficient font, colors, different font styles to put the person on notice? All the normal 5-step factual inquiry this court has adopted you to have to do. Or if it's not linked but just referenced, what does that mean? Is it referenced that there is a term of service agreement?
So what your adversary says in response to that is it really doesn't matter because they continued to use it. They continued to, what's her name, Guillen?
Guillen and Rose both continued to use it.
Yeah.
But we contend not only were they not informed of the, to be precise, not only has Mercedes-Benz not established that they were informed of the terms of service agreement when they renewed, they haven't established it in the initial subscription phase.
If you accept for argument purposes, and I know it's not your position, just accept it for discussion purposes, that the initial assent is there, okay? Does the continued use alone, is it sufficient for assent at the renewal period as a legal matter?
As a legal matter, that's an interesting question. Of course, if there was an amendment, and here there were amendments to there's 2 different terms of service agreements that are included in Mr. Griggs' declaration. If there's any amendment, certainly the consumer would have to be put on notice of those for there to be any legal significance of their resubscription or continued use of the service. In this case, we don't know what they were told at the time of the renewal. If there was no change in the agreement, does the renewal constitute, what do they think they're renewing? I mean, I guess in the hypothetical, and I disagree with the court, that they were told. But if they were told, if they were provided a copy at the dealership, here's the terms of service agreement, take 10 minutes and go read them and then sign this, then do I think that that would somehow not carry forward to a resubscription? I would think likely not.
Is there anything...
But that's not, I'm sorry?
Is there anything to indicate that between the time Mr. Rose or Ms. Guillen initially subscribed and then renewed, that the terms of service changed? Because I think there's one on like a 2013 and a 2016.
Correct.
But Mr. Rose and Ms. Guillen, Mr. Rose comes in later, right? So 2021.
They had different. Mr. Rose was 2017, I believe. And Ms. Guillen was 2015. So when she initially subscribed to the Embrace service, she would have been under the 2013 terms of service agreement. When Mr. Rose subscribed in December 2016, he would have been agreeing to the 2016 version of the terms of service agreement. But, and this is the point I wanted to complete. The misconception that Mr. Rose and Ms. Guillen were provided with the terms of service agreement comes from paragraphs 16 and 20, because that's the only That's the only place in the record that there's a statement made that Mr. Rose received copies of the TOS agreement multiple times, including in connection with his initial subscription and his second subscription. But that is preceded by the clause, as described above. As described above, the plaintiffs were provided with the terms of service agreement. But if you look at paragraph 4, paragraph 5, paragraph 7, nowhere does it state that the plaintiffs were provided with the terms of service agreement. And that is significant for the court to be concluding, the district court to be concluding as a matter of law that it did, that they were on notice of that terms of service agreement. And that's where the court erred. This should be sent back. I respectfully submit this should be sent back to the district court, either to reverse its ruling or for further findings to see what actually happened, both at the initial subscription stage and in any of the renewal subscription stages.
Okay. All right, hearing no further questions, Mr. Wright, thank you. Mr. Wilkerson, thanks to you. Thanks to your colleague. We'll take the appeal under advisement.
Thank you, Your Honors.
And that concludes our arguments.